For various items, one.
In this case, as part of last order, your lordship has passed an observation, my lord, asking the service of the report of the OP number 2, my lord.
Now please start to respond.
No, I see. So since they have not appeared, my lord, I'll pray, my lord, and amicus curiae may kindly be appointed, my lord.
Yes, who can be appointed?
Kak korito. Well, there must be a list, my lord.
Okay. The list of legal aid counsel. Part Mr. Z. Kamar, learned senior counsel, assisted by Mr.
S.J. Chaudhary.
learned counsel for the petitioner. No, for the accused, and Mr. Barthakur, learned additional petition for the state respondent number 1. Mr. Barthakur has produced a report of service of notice upon respondent number 2. But the respondent number 2 remain unrepresented today. In that view of the matter.
তোমার অসুবিধা নাই
Oh, no.
আকৌ কপি দিব লাগিলে
Mr. U. Chaudhary, Ujjal Chaudhary, be appointed as legal aid counsel. Legal aid counsel to represent the respondent number 2. Rest shall furnish a copy of this application along with the relevant papers to Mr. Chaudhary well in advance, and rest shall list the matter on.
Malak, can it be on 38th, my lord, this month? Please do. Much obliged.
Orders, item number 3.
This is ready for hearing, lordship, that can be disposed of at this stage. They have
It is listed in the column of orders.
order column because they have filed an IA for vacating the interim order pass in the civil division petition, lordship. Here, issue is very simple. By an order dated 27/2/2018, the learned court below had took the presumption.
No, Mr. Sunsetti, are you ready to argue the matter?
Very simple.
Okay.
Very simple.
Okay.
Parties are the brother and sister. So their whole case is that their predecessor in interest was the owner of 27 bighas, 3 kathas of land. So out of that land, their mother and the brothers have sold total 19 bighas, 2 katha, 10 lessas of land. And their case is that whatever land they have sold, due share was given to the defendant number 1 and 2. They are the sister. And they have acknowledged the receipt of the due share. And to that effect, they have exhibited two receipt appearing the signature of the defendant number 1 and 2. But the case of the defendant number 1 and 2 is that they never receive any amount from the ancestral property, and the signature are not of their signature, appearing in the exhibit number 7. So after that, after examination of witnesses of both the parties, the case was fixed for argument on 8/11/2016. At that stage, the plaintiff filed an application under Order 26 Rule 10A for sending that exhibit for FSL. So then, on 10/11/2017, page number 53, lordship, the counsel for the defendant number 1 and 2 was representing the petitioners before the trial court. Himself filed an objection without intimating about the same to the petitioners. Page 53, lordship. Page 53. This objection was filed by the council without intimating the petitioners that a application has been filed by the plaintiff for sending the document for FSL examination. So at that time, the petitioner doesn't have the contract with their council. She was in outside of the Gauhati. Then, Lordship, on 18/1/2018, petition was allowed. Page number 55, Lordship.
Mm.
Upon hearing both the parties, the said petition was allowed, and accordingly, last part 56, in the last part, so for allegation of, let's getting last part. So for allegation of not producing original Exhibit 7 is concerned, it was found that the original Exhibit 7 has also been marked and the same was returned to the plaintiff side after keeping the compared with the original copy in record, for it cannot be concluded at this stage as to whether the said document is manufactured, and therefore the objection to that effect is not sustainable. The petition is disposed of accordingly, fixing 31/2018 for appearance of the defendant number 1 for giving her specimen signature. So till that time, the petitioner is not aware about that she was directed to ask appear before the court below for giving specimen signature. Then, Lordship, on 31/2018, page 57, the counsel for the petitioner intimated the court that the defendant number 1 is not aware. Page 57, got it, you know. That the second paragraph, that the defendant number 1 was not aware about the order dated so and so, thereby is not in a position to come this honorable court. Then again on 27/2/2018, page 60, the counsel for the petitioner intimated the court that he is trying to contact the defendant number 1 but failed, and also issued notices. By this page 60, this petition, he stated that they're trying to contact the defendant but has failed in contacting her. And further stated that he has issued an advocate notice to the defendant number 4. That is at page 64. Page 64. You know, got it. In the notice, the address is not of the defendant number 1. Wrong address has been mentioned by their counsel. The address is totally different. So therefore, this notice was also not served. Then, Lordship, at page 65, Annexure 9, the learned court below draws the adverse presumption against the petitioner that the signature presumed to be the signature of the defendant number 1. Last part, page 65. Since the case is an old pending one and already sufficient time has been granted for appearance of the defendant number 1, but as he is avoiding her appearance, this court thereby draws adverse presumption under section 114G of the Evidence Act against the defendant number 1, Deepika Bordoloi. Consequently, petition is rejected. So adverse presumption has been taken. So after then 9/4/2018, the petitioner, the counsel for the petitioner, the said counsel again filed a petition, page 68, that he could not able to contact the petitioner. Page 68, Annexure 11. Paragraph number 3, you know, Lordship. Since the date of passing of the order, the petitioner has tried all means to contact the defendant but failed due to various reasons stated below. So till that time, 9/4/2018, the petitioner is not aware about passing of the impugn order dated 18/1/2018. So in April 2018, somehow the petitioner came to Gauhati and came to know that the order has been passed, and accordingly she filed an application at page 77, Lordship, for recalling of that order. 77, Lordship, got
Mm.
page 7, annexure 14. Second, but the petitioner herself is a cancer patient and has limitation of movement as such had been assisted by her husband from time to time. The petitioner's children are staying abroad, and after the death of her husband, late B.K. Hazarika, the petitioner had no one to take care of her India and was compelled by her children to accompanying them to United Kingdom. The petitioner, along with the children, left India along with her children on 7/6/2017 from Delhi to London. Then para 7, unfortunately on petitioner's family friend, Suresh Kumar suffered a stroke and was bedridden. Suresh Kumar expired on so. He was contacting in between the council and the petitioners. The house in which the petitioner had been residing at Silpukuri has been demolished and for new construction, as such no one residing there. Due to the reasons stated above, the petitioner is not aware regarding the order passed by Your Honor on 18/10/2018, asking her to appear before Your Honor for specific signature in Assamese language. That the petitioner have not avoided in appearing before the Honorable Court, neither the petitioner has been negligent. So accordingly, the petitioner prayed for recalling of that order. Interestingly, Lordship, this application has not been considered by the learned court below as yet. Reason behind this, after filing that application, the plaintiff number 1 and 2 and 3 file an application before the learned trial court below that they want to transpose as a defendant instead of plaintiff. So thereafter, that was allowed by the learned court below on 8/3/2019. Being aggrieved by that order, the remaining plaintiff approached this honorable court by way of a revision petition, and this honorable court stayed the proceeding. So thereafter, this honorable court vide order dated 5/6/2023 remanded the matter before the learned court below, page 87, Lordship. Page 87, remanded the matter. Last page 19 is the relevant part, Lordship. Taking into account that the vide order dated the further proceeding in the title suit number so and so has been stayed, this court, in view of the disposal of the instant petition and taking into account that the parties are duly represented, direct the parties to appear before the learned trial court on 6/7/2013. So thereafter, after remanding back the matter, the learned court below vide order dated 29/9/2023, annexure 18, page 92, dismissed that transposition application, stating that the plaintiff cannot transpose after contesting the case, cannot transpose as a defendant. Thereafter, on 18/12, the plaintiff number 5 died. So accordingly, their legal heir was substituted. And on 6/3/2024, the earlier set of counsel of the petitioner withdraw from the cases. And thereafter, the court notice has been issued to the petitioners. So till this period, the petitioner is unaware about the proceedings. After receiving the court notices, they engage a new set of counsel, and new set of counsel, after going through the entire record, found that this order has to be silenced. Accordingly, this revision petition has been filed. The plaintiff will not cause any, it will not cause any prejudice if this petition is allowed and the petitioner is ready to give her specific signature to that effect, whether that signature is, and the earlier counsel, without intimating the fact, he himself filed the objection before the learned court below against the application seeking for specific signature. So this is the case, Lordship. This application, the file by the petitioner at page 77, has not been disposed of by the learned trial court below as you. And accordingly, the matter is fixed for final argument. It is an admitted position that the petitioner number one is a cancer patient, and at that relevant point of time when the impugn order was passed, she was not in Gauhati. She, along with her kids, are in the United Kingdom. So therefore, she was totally unaware about the order passed by the learned court below and the direction given to her to appear for giving her specific signatures. The defendant is ready to give their specimen signature to honor the controversy. The basic controversy is that whether the signature appearing in the exhibit 7 or of the defendant or not. Plaintiff claim is that whatever land has been sold, the due share has been given to the defendant, and they have acknowledged the receipt of the share by way of that money receipt exhibit 7.
So this annexure 14, page number 77 is yet to be disposed of.
Yes, Lordship. That has not been considered as yet, because after filing this application, the defendant number, plaintiff number 2 and 3 filed transposition application that was allowed. Against that, the remaining plaintiff preferred revision petition before this honorable court. So suit was stayed. Ultimately, this revision petition was allowed, remanding the matter before the trial court, and the trial court ultimately dismissed the said transposition application. So thereafter, the plaintiff number 5
Okay.
expired.
Mr. Sansete, what is your stand here?
This suit is filed by the plaintiff. Against the defendant of the case of that applicant, and cancellation of sale. Out of the defendant number 2, one of the sister, she did not file any petition. Even she has not also disputed her signature.
No, Mr. Sansete,
That
you
was-
see,
that was-
this
yes.
petition, annexure 14 is yet to be disposed of by the trial court.
That was considered. What is their whole case? Their whole case.
No, is it not disposed of? This
They did-
annexure 14?
No, they did not press order. There is also order, that they have neglected. Before that matter, I want to get some explanation regarding this order, impugn order at page 65.
Mm.
They have telling this impugn order after expiry of about 7 years. That was first 27/02/2018, page number 65.
Mm.
Thereafter, my lord, they have filed an application which your lordship have pointed out at page 77, petition number 160380. That petition was filed by the defendant number 1, supported by the affidavit. And she challenged that order should be revoked. Thereafter, next date was fixed, my lord, by the honorable court. Your lordship may come at page number.
No, Mr. Sansete, you say,
Yep.
though they have challenged this order 27/2/2018, yet one petition is pending before the learned trial court.
And not pending, sir. My lord, your lordship may come at page number 82, my lord.
82.
Yes. Only last line I am reading, my lord.
Mm.
060613 fixing 0604 objection heading on petition number 17328 and 160380.
Mm.
That was finished. Thereafter, your lordship may come again at page number 84. First, they did not come before the honorable court. Subsequently, they come. So on the same day, another order was passed. That is next order on page number 84, 6680. My lord, I am reading. Both parties are present. London calls for the plaintiff, defendant number 1 has filed petition number 2099, adjournment to file written objection of petition. On that date, my lord, they did not press that petition. So that was fixed for hearing, my lord. That particular case was fixed for hearing, but they did not press. Instead of that, they have filed another 2 petitions, my lord. That is the position. Thereafter, about 7 years have passed, they did not come. And here only the regarding this, I am telling you that They have stated that defendant number 2 did not put her signature on exhibit 7.
Oh.
That was marked as exhibit 7. But just another defendant, her sister, she did not raise any objection, and she also disputed. So why they were sleeping over about 7 years? So many dates was delayed, but they did not find. Now, okay, actually, they have come, my lord, only to delay. This is suit filed in the year 2010, my lord. Twice this case was fixed for judgment. When the case is fixed for judgment, they file a petition, I get an adjournment, or that is the position. But they did not manifest. My lord, on 6/6/15, they did not place that petition. Who has prevented? They have not. They themselves stated that we shall not place. I know they have filed another 2 petitions by order dated 6/6/18, my lord, which I have pointed out at page number 84, my lord. That is petition number 1, so. Only by dealing practices, nothing is illegal, my lord. Only dealing practices, my lord. Under the law, my lord, it is their ability when they have denied to file an petition. But instead of them, I have filed that petition.
No, this petition is yet to be disposed of.
No, my lord, they did not press, my lord.
No.
They did not press the petition. When the court asked, that petition was filed on off date. That petition 1603 was filed on off date. When the date
No,
was
no,
not fixed.
Mr. Sansete, you show me any order passed by the trial court upon this petition.
No, because only the date of hearing was fixed, my lord, on that petition.
Then how can it be said
Then-
that the petition is disposed of?
But because the hearing was taken, I was also present, other side also present. But instead of that, they are making submission on only 2 petitions.
Let's say I'm
I-
clarifying
yes,
this. That's it.
yes, okay. That was the position. Then, if that was, they could have filed another petition on the next date also. They have not filed any petition, that no hearing was taken up on that petition, my lord. After 7 years, my lord, they have come by filing this revision petition, my lord. So my submission only dealing petition, and I nothing more, my lord. That is my submission, my lord. Because I am fighting since 2010, my lord, and senior citizen, my lord.
No, that's all right. But the problem is that no effective order has been passed upon the petition filed by the petitioner.
If your ownership has been proper, if that specific direction may be issued to dissolve this petition within a particular period. That from submission from my side. Because very old case. So a specific direction may be given to dissolve that application, if that is not disposed of within a particular 1 hour. Date at your that is also.
Let's see. Because we have filed the application for recalling of that earlier order. If that order is recalled, then everything is.
Or that is also not that great. That is something.
No, let's see.
It's a matter.
10-5.
They have challenged that order, 27-2, not that order, 6/6/18. Is that,
6 is totally different, my lord.
No,
10-5, the case was fixed for only 10-5. There is mention of 2 petitions. One filed by the defendant number 1, that is 1603/18, and another filed by the plaintiffs under order 1 rule 10-2, that is petition number 1732. And that was fixed on 6/6. 6/6, the plaintiff filed a petition seeking time to file objection to the petition number 1732, and the defendant filed another petition to file objection to the petition number 1603/18 filed by the defendant number 1. That is reflected. Both parties are present. Learned counsel for the plaintiff and defendant number 1 has filed petition number 2099/18 and 2098/18. Accordingly, praying adjournment to file written objection. Prayer is allowed. So if both the parties have sought for time for filing objection either of the applications. So thereafter, this application has not been considered because in the meantime, the suit has been stayed.
Whether any stay order is operating?
Yes, Lordship. The further proceeding of the suit has been stayed by this honorable court. In
Okay.
The case was fixed for judgment.
Okay, you suggested that on which of both the parties may appear before the
But
trial.
we can fix after 15 days.
What?
Any date, Lordship. Remanding. Direct.
First week of May. 6th May.
6th May. Oh,
Okay. Will issue direction to the trial court
yes.
to dispose of the petition
Petition.
after affording opportunity of
To both
being
the
heard to both the parties. You appear before both the before the trial court on 6th. 6th May.
Lordship, another difficulty is 14.5 matter is fixed because after staying, date is given in the equal services. 14.5 is the next date of the suit.
Okay, on 14/5 then.
Or
14/5.
Oh,
14/5. Yes, next item.
Appellate.
Item number 4.
May I please, your lordships? Well, this is I for stay of the by lord execution proceeding. The main RSA has already been admitted by your lordships on 16/3/2026. But IA has not been disposed of. 16/3/2026.
Whether any execution case has,
Well, execution is pending, my lord.
what is the number?
Number is given, my lord, that is execution case number 37 of 2025.
Where you have mentioned it?
My lord, in IA, my lord.
Para number.
In prayer, it is written 37, and in paragraph 4, it is written.
Heard Mr. Anhock, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure, read with Section 151 of the Code of Civil Procedure, is prepared by the applicant for staying the proceeding of title execution case, being the title execution case number 37 of 25, pending before the Court of Learned Civil Judge Junior Division number 1, Barpeta, for execution of decree dated 30/3/2021, first entitled suit number 73 of 2014. Mr. Hawk, learned counsel for the applicant, submits that the applicants have preferred a second appeal, being RSA number
163.
163 of 2025, and this court was pleased to admit the same by order dated
16/3/2020.
16
16/3/2026.
16/3/2020
Six.
26 16/3/2026, and by formulating substantial question of law, and also call for the record. And he also submits that in the meantime, the respondent hearing, the opposite parties hearing, have instituted the title execution case number 37 of 2025, and unless the said title execution case is stayed, this the RSA number 163 of 2025 would become infructuous in the event of execution of the decree dated 30/3/2021, passed entitled September 73 of 2014. Having heard the submission of Mr. Hawk, learned counsel for the applicant, this court has carefully gone through the petition and the documents placed on the record, and it appears that RSA number 163 of 2025 has already been admitted by this court after formulation of substantial question of law, and the record of the trial court as well as the first appellate court has already been called for. And considering the aforesaid facts and circumstances, and also the submission of Mr. Hawk, learned counsel for the applicant, further proceeding of title execution case number 37 of 2025, pending before the Court of Learned Civil Judge Junior Division number 1, Barpeta, stands straight till disposal of the RSA number 163 of 2025. In view of above, this ISM disposal.
Obliged, sir.
Item 5.
May it please,
In this case, we have taken steps upon the respondent, my lord. The service is awaited, my lord. Oh.
My lord,
You are for?
I am appearing for the response.
Okay. Service is
I
complete.
may be given just 3 weeks time so that I can.
For all the respondents?
Yes.
Okay. Heard Mr. Z. Alam, learned counsel for the petitioner. And also heard Mr. Nandi, learned counsel for all the respondents.
Both, except 3. 3 is yet to give the color.
For all the respondents except respondent number 3.
3.
3. No, you have not received any instruction.
No, I have yet to receive the instruction.
Okay. Mr. Nandi submits that he has yet to receive any instruction to appear on behalf of the respondent number 3. In that view of the matter, recess list the matter after a week so as to obtain instruction regarding appearance
Appearance
for respondent number 3
Yes.
after 1 week. List the matter after 1 week so as to enable Mr. Nandi, learned counsel for the respondent, to obtain instruction as to whether he can appear on behalf of respondent number 3 or not.
This is interim order.
Interim order pass earlier shall continue.
Obliged, man.
Question 25.
May I please address? The office note dated 27/3/26 shows that the notice to the respondent number 8 and 15 has returned unserved. And respondent number 5 is awaited.
Then
No such person.
you are referring to office note dated 10/6.
27/3/2026. Red flag.
Recent.
27/3/26.
Yes, yes.
31/3%.
No, there is no such office note.
That's it.
Office note dated 27.
27/3.
এটা এনেকে কয় নেকি?
Office note to the left.
So as per this office note, service not completed in respect of respondent number 8,
And-
15 and 5.
Yes, sir. The 8 and
So
15
you have to take fresh steps,
steps I have to take a
instruction
instruction to the present
in respect of respondent number
8 and
8 and
15.
15.
Lordship.
Heard, Mr.
A. Burwa.
Learned counsel for the appellant. Office note dated 27/3/2026 indicates that unserved notice issued to the respondent number 8 and 15 returned with a report that no such person is available in the address and returned to the sender. And said office note also indicates that neither ID card nor unserved notice issued in respect of respondent number 5 has been received by the section till date. Accordingly, it is provided that learned counsel for the appellant shall obtain instruction in respect of the correct address of respondent number 8 and 15. and thereafter take step upon them by speed post and also by usual process within a week from today. In respect of respondent number 5,
It may be awaited, Lordship.
awaited,
Lordship.
list the matter after
4 weeks. Lordship.
4 weeks, awaiting service report upon respondent number 5 and also upon respondent number 8 and 15. 8 and 15. List after 4 weeks.
Obliged.
Item 26.
May I please, Lordship? Lordship, in this case, Lordship, I filed on IA Lordship for implementing Lordship. Respondents, Lordship,
When did you file it?
Lordship, 7/4 Lordship, but
7/4
Lordship, matter may be listed, Lordship, in next week, Lordship,
on
next week, Lordship,
next week.
Lordship, any date may be fixed, Lordship. IA number 421026, Lordship. There is a minor mistake, Lordship, committed by Lordship, a defect, Lordship.
They want to substitute your document.
No, that's all right. The system has not shown your application.
No, Lordship, not yet numbered, Lordship.
It will be numbered.
Okay.
Next,
Third,
Lordship,
Mr.
B. Malakar, Lordship.
Learned counsel for the petitioner and Mr. Laskar for the respondent. Mr. Malakar submits that he has filed an interlocutory application for implement of
Responding number
legal heirs of respondent number 1A.
1A
1A.
and 5.
1A. And the same has not yet been registered and placed on record. And as such, he pays for listing the matter in the next week. Fair allowed, recessal list the matter in the next week and closing the interlocutory application filed by the
Lordship.
petitioner hearing. List accordingly.
Lordship, a date,
You want date, your lordship. Next week, lordship. Any date, your lordship. No, next week.
29. Lordship.
Obliged. Item for hearing under Order 41. Item number 2.
May I please, your Lordship? Lordship, in this case, I was allowed to file, my lord, recasted substantial question of law, which my lord I have filed. Your Lordship, I cannot see. Office note dated 6/4/26, my lord. Those have been marked as flag X.
So allow me to say, this is second appeal. In second appeal, this court is not entitled to appreciate the facts.
My lord. Definitely, my lord.
Hmm.
But my lord, why?
So your first substantial question of law is that error in facts and law.
law, my lord, affecting rights of the parties, my lord. If these findings, my lord, affect the rights of the parties, then this, my lord, this becomes a substantial question of law, my lord. My lord, if this of my presentation, my lord, I have come up the judgment of 2005, 7 SCC, page 60. Yes, sir. Sir, 2005, 7 SCC. May I read paragraph 7, my lord? Paragraph 7, my lord, of the judgment, my lord. May I read? Last sentence of paragraph 7, my lord.
The question is, you have to demonstrate how the impugned judgment and decree
My lord,
adversely affect your rights and
My-
title and interest.
my lord. Your, for this purpose, your lordship cannot see. Page 119. Page 119, my lord. My memo copy. These are the findings and these are recorded by the land appellate put below, my lord. And relevant is, my lord, page 122. Paragraph 23 of the impugned judgment and decree. Page 122. My lord, paragraph 23.
Paragraph?
I peruse the family arrangement. My lord, the sole basis for passing the impugned judgment and decree by the appellate court is on the basis of exhibit B. This is family settlement deed, my lord. Arrangement that was entered into between Gopichand Agarwal, Prabhu Agarwal, Rajesh Agarwal, and Pawan Kumar Agarwal. If the terms of the family settlement, terms of the family arrangement is carefully considered, it is said, seen that the property at Nurul was given to Pawan Kumar Agarwal and property at Madanganj, Kishanganj, Rajasthan was given to Durga Prasad Agarwal. The property at Barpathar was given to Gopichand Agarwal, and property at Bokaghat, which comprises of Bajrang Mill and Ratan Agarwal rice mill was given to the share of Prabhu Dayal Agarwal, subject to payment of this rupees 44 lakhs that was to be made by Prabhu Dayal Agarwal was to be given to Rajesh Kumar Agarwal, and rupees 9 lakhs was given to Gopi Chand Agarwal. So, my lord, the respondent hearing, my lord, who is the appellate before the appellate court, has failed to discharge his bonus, my lord, that he has complied with the terms of this deed, my lord. Hence, he is entitled for getting benefit on the basis of this deed, my lord. No evidences are there before the trial court. Furthermore, my lord, in para 23, your lordship can see, there were 4%, my lord, who had executed this family arrangement deed. Wherein, my lord, predecessor in the details of the present appellant was not the signatory, he was not the party. Para 23, my lord, Gopichand Agarwal, Prabhu Dayal Agarwal, Rajesh Agarwal, Pawan Agarwal. Petitioner appellants before your lordship are the legal heirs of Durgalal Agarwal. He was neither party nor signatory of this instrument, my lord. And my lord, suit property has not been shown clearly in this exhibit B, my lord. Despite of that, my lord, degree has been passed in favor of the respondent, my lord, by the appellate court, effecting rights of the appellant. While furthermore, there is nothing on record that any property was given to the share of the predecessor in interest at Rajasthan, my lord, pursuant to this family settlement deed, my lord. Nothing on record.
So the trial court has decreed the suit in your favor,
Partly degree, my lord,
partly.
partly degree. In favor
And
of
the
the
same was reversed by the civil
Appellate
judge, appellate court.
appellate court, my lord.
First
In
appellate
appellate court, my lord, control claim was decreed. Before the trial court, control claim was dismissed, my lord. Suit was partly decreed. Before the appellate court, my lord, suit was dismissed. Control claim was allowed.
Okay. Mr. Borua, you are appearing for the respondents.
At the outset, my submission will be to vote. Hey, earlier in few occasions, I have raised one question before this court, and whether in fact this appeal is itself eligible or not. Because of the fact now the substantial question which is I will submit it is not a substantial question of law. Substantial question of law is a different, and they have to show whether the question is arised from the judgment. That is right. By taking one observation, it is not come up to a substantial question of law. And for the first question, I will go one by one. The first question was that whether judgment decree put by the party current appellate court was supposed to error facts and law. If it is taken as if it is a submission, that is not a substantial question. Substantial question is on the basis of the question, not on facts. And what is the question around? What is the wrong committed by the trial court? They have to show. Second, we find that these are the involved question is entire matter available on record, there is evidence of no record. Where? From where they say? that entire material available on record and there will be evidence or not. Can it be a substantial question of law? See such a way, the way of such a way substantial question will be framed. Third is also another. Whether judgment and decree learned are perverse and non-application of man. How it can be? Non-application of mind can be a, he have to show the judge have nothing considers anything. Non-application of mind. It is a second appeal lordship. It is not a we are appearing before the first appellate court. And it third way, next one is fine. It is not a substantial question of law. It is itself. And fourth is a question of facts. How that can be a substantial question of law. And moreover, I want to submit another three things, lordship, because I have compelled to say these things.
No, this last one, Mr. Borua, you come to the last one.
Last one is a question of fact. But question of fact, how question of fact can be considered in the substantial second appeal?
My lord,
And-
this relates to
I'm
one.
submitting.
Yes,
I'm
sir.
submitting.
Sir, please, sir, please.
Now, lordship will say, it is a case. I compared to Gauhati. In this case, I not.
Mr. Borua, Mr. Borua, you say, if exhibit B
Yes.
is not a relevant document here, but the learned appellate court has taken note of the same and relied upon the same, pronounced the judgment, then would it not be a substantial question of law?
No, lordship is fine. I am. What is the answered by the court? What is the question point? There is a fourth point of determination in the case. One pick up the point, and here is not something else. Logic cannot be a substantive question, not defined. The question is the number of question of facts. This cannot be. If their case will be there in the trial court that or appellate court that the document is false or document is not, that is different. Here is lordship, what is observation? One paragraph is lordship 23.
Mr. Borua.
20. In 24.
Mr. Borua, you say he has submitted that the appellant herein is not a party to the family settlement agreement.
That is answered by the court. That is answered by the court. Here they themselves say in the whether they have raised in the appellate court or not. They have not said it in the trial court also. What is this?
This was exhibited as exhibit B.
What they, how it is a family settlement. When a family settlement is acted upon, that what is there? They said on the basis of the family settlement, they have already enjoyed their portion at the Rajasthan. They said they have already portion. Don't you will find. It's a long paragraph, 25. 25 then under 20, you have to read for that point, 23, 24, 25, and all. I read the I read the whole discussion, Lordship, starting from page 20, paragraph 20. The court itself says page 125, if you lordship have shorter, and I have good. Para 27 watchable time and everything else, and it will be indicated in para 27 of the judgment, page 126. The court, however, the court,
Yes,
does not agree the decision arrived by the learned Municipal Court Bokakat with regard to the finding on giving effect of the clauses of family settlement which had been mentioned above did not have any connection with the petition interest of the respondent and was linked to the two other signatories in family settlement. Respondent primarily the respondent number 2, Srimati Sunita Agarwal, has admitted that she now run and possesses Dunga Powerloom factory at Manchan Kajana and the Powerloom factory had fallen into the share of her father as per family settlement and no material on record brought on record the plaintiff or respondent so that the said Powerloom was acquired by Dugaras Agala by any means done by dint of transfer of family settlement and that is entered within it. And this is the presumption that family settlement indeed acted upon. After the acted upon a family settlement, how they can now question over the veracity of the family settlement? And I will notice another aspect of this case. Who was appellant number 1? Can you see? This is a case when a case, I have aggravated matter in this, I know. When a person make a case with a not bona fide nature, always they suffers. And this is the case logic. Appellant number 1. Who is appellant number 1? Appellant number 1, right of appellant number 1 is rejected by the trial court. That he has no right of body land, he is not an adopted son. And that question, he never filed an appeal or cross appeal in a case against that observation. Therefore, he have no right to file second appeal. The law is that what is the law of the civil procedure? That when a person agrees with a judgment, if he not challenge the judgment in the subsequent appellate court, he has lost the right. And now the power of he here also filed this appeal the same way as a power of attorney holder of the appellant number 2. If lordship go to the every scenario, how one on the take the help of the others want to grab the land. That is the one case. This is the case. The appellate court they came to know that this is actual fact. So the right of this appeal is a statutory right and must follow the specific procedure. Once you have not challenged the finding.
you saw the finding of the trial court
Yes.
in respect of the appellant number 1.
Case lordship will. No, okay. Even directly come to the orders, case 19. I 94. Case 94. Orders if para 2 lordship. 92 para 2 lordship fine. The further, this is the right of plaintiff Nilesh Agarwal was not established as such. It should and deed of adoption plaintiff number 1 held to be ineffective, illegal, innovative in law. That is the trial court judgment.
So this finding is not challenged by him.
Not challenged. That finding is not challenged. If they not challenge that appellant 1 or their judgment, that attend finality. And how does it they can come in second appeal? Only taking the center of the appellate number 2. They, it is the main thing Lordship will have to see that how the fraudulent take place, how they are not bona fide. And that is why in the appellate judgment, he did part. If you go to the entire appellate judgment, in the first part of the appellate judgment, it is specifically said by submission that I am on the question of plaintiff number 2. This appeal, that appeal. Because plaintiff number 1 already been there, excluded from that right. They have not filed cross appeal. We have given chance, making them a party of the second, first appellate, but I know that it will come. Because he is a respondent, plaintiff was of the first appellate, but they have not filed any cross appeal, never raised any question on that. They have never raised a question on the, they know, they have already enjoyed. And the plaintiff number 2, the appellant number 2 already admitted that they have enjoyed the huge property at Rajasthan on the dint of this agreement. But plaintiff number 1 have already taken their part and go ahead. Now, as they are saying it outside, this son of the and another interesting, and for that they make a adoption for adoption, illegal adoption to only for the property. The child body rightly discarded his right. Appellant number 1. Specific is that he cannot be adopted. His adoption is not valid.
No, Mr. Borua, you see, this appeal is filed by Sunita Agarwal also.
Here, this Neeraj Agar, the appeal.
Yes,
This appeal.
yes, apart from this Nilesh Agarwal.
And the Sunita Agar give power of attorney to 1, appellate number 1, affidavit, that question also raised in the foundation, that case apparently disposed of by this court. And that, at that time also that they did raise it in the when the appeal is come. And I also does it fine. I did now I have found that I am the I don't say burden of the I am the appellant number plaintiff number 1 on this case, taking steps. This case on behalf of the appellant plaintiff number 2, Sunita Agarwal, as her attorney and conversant with the fact and circumstance record. Now, when he fails to get the favorable order in the trial court, he never now appellate court also taken in consideration that now only to grant the property. Nothing else. In fact, if appellant number 2, he's admitted he already, I've shown in procedure, already he acted upon and already he taking their position and they on dint of that agreement they acted upon. And now, therefore, is whether signature or not, that is a question of fact, that cannot be a question, number 1. Whether judgment, these questions cannot be a question. Recently, the judgment.
No. Mr. Borua, you see, he is not a party to the family settlement deed.
No, he
is not a signatory to the same.
Yes, he himself says that document, the exhibit, the exhibit family settlement, he never said he was not a party in trial court. He moreover, his evidence, he said that on the dint of that family settlement, even lordship proving there is no document at all. If orally we have settled the family, we get together and say that we did not have together. And after that, we take this for suppose it is such a case. we, on the date of our agreement, we have taken our share and we put the thing in the chair.
Mm.
Can he now say, after admission, that we have not been doing this? Because we have already, you take their share. And on dint of their share, that is the, very correctly, it's a very good, the judgment is, in fact, it's a very judicial judgment. And the appellate court, and giving the, only that point, the honorable trial court, last 4, 5 paragraph on that, on the document. And correctly said, and said that how, every point of is answered by there. Even those questions whom I was not, in fact, I am the Agu did that appeal in the Gulaga. I am not even raised in such in this that point. After there is two part of the judgment was they have not raised that yet. We have raised the maintainability of the suit. The court, apart from that, they said the suit in such form is not maintainable. But they have not raised any substantive question of law here. Because they filed a suit. Very interesting was the thing. Filed a suit for first possession and permanent injunction of a property without any declaration.
Mm.
And
Okay,
moreover, that is not
so
answered.
according to you, none of the suggested substantial question
Yes.
of law are involved here.
Yes.
Okay. Heard, Mr. N. Alam, learned counsel for the appellant, Mr. Borwa for the respondent. Argument concluded, order reserved.
Clear only one point, as my respected senior has said. Lordship, I cannot see suit was filed by 2 persons, my lord. Brother and sister. Brother for himself as well as attorney of his sister also, my lord, suit was filed. By the judgment and decree of the London Trial Court has granted entire relief to the sister, my lord. Brother was not agreed. He was satisfied that property has been given to his sister, my lord. Therefore, my lord, appeal was filed. Your lordship cannot see their appeal. In member of appeal, they have been pleaded both. They ought not to have pleaded, my lord, appellate number 1 before the appellate court, my lord. Now, my lord, appellate court has reversed the judgment of the trial court, effecting right of the appellate number 2. So, my lord, appellate number 1 has not sought for any new thing before this honorable court. My lord, just as attorney, my lord, this appeal has been filed by appellate number 1 for and on behalf of appellate number 2, my lord.
Okay.
Can it be said he filed appeal without any claim? That is very interesting. He said they filed the appeal, but without any claim for him. But what is this?
Attorney can file, my lord.
Attorney can file,
Attorney
he
can
cannot
file.
make an appellant. He can file an affidavit. But how he can even make a party to the appeal?
Okay.
Much
Okay.
Items for hearing, item number 7.
May I please, your lordship? My lord, this is the suit filed by the
So the appeal is admitted on 2 substantial question of law,
yes,
A and B. But the question is whether these are substantial question of law.
Yes, my lord, these are substantial questions. I should satisfy your lordship.
Hmm.
Because exhibit Q and Q, these are the two cell deeds. Two cell deeds, and the certified copy of the two cell deeds were exhibited.
Hmm.
And that exhibit, that was admitted without any objection from the other side.
Hmm.
The learned courts below did not consider this exhibit Q and Q. If exhibit A, Q and Q is considered, then the suit of the plaintiff is to be dismissed.
Hmm.
Therefore, the exhibit Q and Q, whether this is admissible or not, because it is a certified copy of the seal deeds,
Hmm.
and it was exhibited without objection. Whether this is admissible, I have the Supreme Court decision on this point. Let
Hmm.
me submit my case.
Hmm.
Malad, the case is filed by one Krishna Sanai and her two daughters against the appellant. And the plaintiff is at page 4. The above paragraph number 2, the above mentioned plot of land was purchased by Vishwajit Sinha from one Radhesham Agarwal by registered cell deed number so and so. The husband of the plaintiff was killed by extremists on the second day of November.
You are reading which judgment?
Judgment, it is a copy of the plaintiff, page 2.
Page number?
Page number 2.
Page number 2.
Oh, sorry, page number 5. The husband of the plaintiff number 1 was an extremist, and he was killed by another extremist.
Hmm.
That is the fact behind this case.
Okay.
That Biswajit Sinha, he purchased a plot of land measuring 2 kotha,
Hmm.
7 lesses. And after his death, the land was mutated in the name of the plaintiff respondents. That the case of the plaintiff is this, that after purchase of the land, she put the defendant on the plot of land to look after.
Hmm.
And there was no other consideration that she will pay some money or salary, nothing. Only stated that he was put into the land to look after the land and to protect from the others.
Hmm.
And she was further stated that when the plaintiff number 1 required the land, he issued a notice to the defendant, which was returned unserved. And now the plaintiff declared that the land is required by her. And my lord, your lordship kindly look to the page 8, paragraph number 12.
Paragraph number?
12, 1, 2. Page 8. That this is the case of the defendant. It is the statement of the plaintiff, paragraph number 12.
You are referring to judgment of the first appellate court.
No, no, madam. Copy, I am reading the copy of the plaint.
The pagination is not similar with your paper book.
Memo appeal. Any memo appeal, my lord?
Is it part of the appeal?
Yes, yes. The memo appeal, your lordship, kindly take. Firstly, the grounds, then the copy of the plaint.
This amended plaint.
Yes, amended plaint.
Okay.
Para 12.
Yes.
That one should thus file a title suit in respect of the suit land against the plaintiff, being title suit number 10 of 1995, before the district judge Bongaigaon, and dismissed on 7/2/98 for default. Thereafter, the Ushudas filed a revision under order 9 Rule 9 Reduced 151. The said miscase before the district judge, and the said miscase was transferred to the civil judge Bongaigaon and numbered as so and so. It was dismissed for non production of witness by the petitioner on the said case. Against the petitioner, Ushudas filed a petition under order under section 151 CPC before the Honorable Civil Judge Bongaigaon, which was dismissed on 13/9/2001. The miscase number. Hence, the Ushudas could not establish the right, title, interest, and cash position over the suit land. That is their plaint, paragraph number 12 of the plaint. And my written statement, your lordship kindly see. My written statement from paragraph 19. Paragraph 9. Paragraph 9 at page 12. That as regard the averment made in paragraph number 1 of the plaint, it is wholly denied, and the aforesaid husband of the plaintiff was the owner and possessor of the scheduled mentioned land. In fact, the scheduled mentioned land was originally owned by Ushot Chandra Das by way of purchase in the year 28/9/1969. You will also kindly note the date. That land was purchased by Ushudas in the year 1969. Right, registered deed number so and so, and got delivery of possession. Since the day of purchase, he was in possession of the land, and later on left to his native place at Golia, keeping one Saligram Sharma in the one part and the defendant on the other part to look after the land, as well as the house constructed therein. Of course, in fact, the husband of the plaintiff, that too purchased the plot of land from one Radhesham Agarwal, subsequently without any right, title, interest over the same, and one Vishwajit Sinha could not be able to get the able to possess the said plot of land, because the land was purchased by Ushut Das from the original owner, and the Ushut Das keep this defendant to look after the land, and the husband of the plaintiff purchased the land from one Radhesham, Radhesham Agarwala must subsequently to the purchase of 1969. And thereafter, your lordship kindly shift to paragraph number 12. As regards the averment made in paragraph number 5 of the plaint, the defendant doubly submits that the defendant came to know the husband of the plaintiff, number 1, and A was a surrendered person, was linked with extremist activities, and he got the land in question in his name, showing the muscle power. Likewise, the plaintiff number 1 mutated her name, her husband's influence, and both the two times the said Osudas raised due objection before the concerned revenue authorities against the illegal mutation. The land was purchased by husband of the plaintiff by force. Even though it is a registered document, but the vendor has no title to transfer the land. In the meantime, he was sorted by the other extremist. Then, my lord, the paragraph number 15, your lordship kindly. Paragraph number 16.
Yes.
That the allegation made in paragraph number 10 of the plaint is wholly denied by the answering defendant. Rather, the plaintiff has no right title interest over the suitland. The plaintiff are not entitled to say about their right title interest over the land. The plaintiffs are not entitled to say about their right title interest over the suitland without impleading the original partner or partners or necessary parties. It is already submitted that the sale deed as executed by Radhesham Sharma is in favor of the Vishwajit Sinha, since this is a fraudulent one and not according with the provisions of law. Hence, no right title interest accrued to the purchaser is legal heirs from the said deed. As such, the same may be rejected outrightly. On the other hand, after a few years of purchasing the land in question by Oshut Chandra Das, the total land measuring 1 bigha 6 lasses, including the suit land of Khatar number 45, tag number 121 of on 28/10/1969, white registered sale deed number so and so. After getting delivery of possession, he has constructed a thatched house in which he occasionally used to live there, and he cultivated the remaining portion of the land to the engaged laborers. They have come in.
Okay. We'll resume after 5 minutes.
Yes, my lord. I have already taken before lordship that the case of the plaintiff and the defendant. My lord, at page 24, issues are there, my lord. whether there is cause of action for this. Five, six.
Yes,
Issues are the whether cause of action, number two, maintainable, barred by limitation. And the issue number five, whether the plaintiff has right title interest over the suit land mentioned in the plaint. And six, whether the defendant is liable to be evicted from the suit land and the plaintiff is entitled to the first position of the suit, the land as mentioned in the suit. There may not come to issue number 9, whether Osudas is a constant possession over the suit land through his authorized man, Sri Saligram Sharma, and thereafter through the present defendant to look after the suit land by executing a general power of attorney. And number 10, whether the suit cases filed by Osudas in different court in connection with the suit land were dismissed on procedural technicalities or on merit. These are the important substantial questions of law. I am coming to issue number 5 to 11. Page 30. Issue number 5.
page number 33.
30.
Okay,
Issue number 5. In order to decide this issue, we have to see the first contention of the plaintiffs. The plaintiff says in their pleadings and during the argument by the learned counsel has stated that the plaintiff has the right title interest over the suit land as the legal heirs of the deceased husband, Vishwanath Sinha. They who purchased the plot of land measuring 2 quota 7 acres covered by DAG number 121 321 old and so in patta number 35 old and 222 situated at village Bharkapara, Bongaigaon, and from one Radhesha Magorola to a registered deed number so dated 7/8/1994, mentioned in the suit land in the schedule. The further contains that the suit land was originally belonged to one Dudnath Sarkar, from whom he purchased by one Radhesha Magorola, and from him the deceased husband and father of the plaintiff purchased the land and took possession. To support and establish her claim, the plaintiff number 1 adduced the evidence of herself as PW1, Radhesha Magoral as PW2, Utpal Sharma as PW3, and exhibited as Exhibit 1 the original registered sale deed number so dated 14/12/1990 in the name of Radhesha Magorola. Exhibit 2 is the original registered sale deed number 614 dated 17/8/1994 in the name of Vishwajit Sinha. Exhibit 3 is a Kasapatta of the suit land issued by ASO Bongaigaon in the name of Vishwajit Sinha. Exhibit 4 is the landholding certificate issued by ASO Bongaigaon in the name of Radhesha Magorola in respect to the suit land on 18/12/91. Exhibit 5 is the non-economic certificate issued by the sub-register Abhaipuri in the name of Radhesha Magoral. In the name of Radhesha, in respect of the suit land, on 24/1992, Exhibit 6, exhibit is a certified copy of the Jamabandi the name of Vishwajit Sinha. Exhibit 7 is the landholding certificate issued by ASO Bongaigaon in the name of Krishna Sinha in respect of the suit land. Exhibit 8 is the revenue clearance certificate from the Tahsildar of Bongaigaon Tahsil dated 14/6/2005 in respect to the whole Patta land. Exhibit 9 is the Jamabandi certificate issued by ASO in the name of Krishna Sharma. The plaintiff case has been challenged by the defendant that the plaintiff has no right title interest over the interest and possession over the suit land, and the actual owner of the suit land is one Oshud Das. The defendant admitting the fact that the suit land originally belonged to Dudnath Sarkar, submitted that the original owner long back from the alleged transaction by the plaintiff with Radheshyam Agarwala in the year 1969 sold the major portion of the land, of which the suit land is also a part, to one Prafulla Dev Chaudhuri. And from Prafulla Dev Chaudhuri, the land was purchased by Oshud Chandradas in the name in the same year. As per defendant, the actual owner and possession of the land, as mentioned, Oshud Das, was purchased from the land measuring 1 bigha 6 lashes of Khatir number 45 of Dag number 121 on 28/9/1969 by registered sale deed number so and got delivery of possession, constructed thatched house and possession of the suit land. My lord, the land was originally owned by one Dudnath Sarkar. Dudnath Sarkar has a vast area of land. He sold this land to he sold 1 bigha 1 kata 2 lesa to Prafulla Sarkar and Prafulla Chaudhuri. From Prafulla Chaudhuri, the Oshuddas purchased the land measuring 1 bigha 6 kata. From Dudnath Sarkar to Prafulla Chaudhuri to Oshuddas. And the plaintiff claim the Dudnath Sarkar sold the land to Radheshyam Agarwal. Radheshyam sold the land to the Biswajit. All the lands were on the Dag number 121. Our land also 121, their land also 121. Therefore, your lordship is to see how much land in Dag number 121. If it is more than it is more or less 1 bigha, then their sale deed is valid. Otherwise, the Dudnath Sarkar sold the land to the Prafulla Chaudhuri is prior to the sale of the Radheshyam Agarwal. Therefore, in support of the case, the defendant examined himself as DW1, Oshud Das as DW2, Srimati Sarvani Devi as DW3, and exhibited some documents, that is, exhibit co, the true copy of the registered sale deed number 1950 dated 26/4/69, executed by Dudnath Sarkar in favor of Prafulla Chaudhuri. Exhibit co is the true copy of the registered sale deed number 3273 dated 28/9/69, executed by Prafulla Chaudhuri in favor of Oshud Das. Exhibit go is the general power of attorney given by Oshud Das in the name of the defendant. Exhibit co is the certified copy of the voter list and election registered in Bongaigaon, showing the name of the defendant. The electricity bill in the name of the defendant. Now, after going to the deposition of the witnesses, I found that both the plaintiff and defendant side has adduced evidence in support of their claim. PW2, the Radheshyam Agarwala, from whom the Biswajit Sinha purchased the suit land, deposed that the original owner of the suit land purchased the land from Dudnath Sarkar. Though through a registered deed number 1399 dated 14/12/1990. On the other hand, DW2 also does depose that He is the owner of the suit land. He further deposed that the original owner of the owner of the entire plot of land, including the suit land, was Dudnath Sarkar, from whom Prafullo Chaudhary purchased 1 6 acres of land to a registered sale deed number 1950 dated 26/4/1969. From Prafullo Dev Chaudhary purchased the land by registered sale deed number 3273 of 28/9/1969. Both the parties have exhibited the respective sale deeds. Accordingly, I am to consider that in view of the at this stage, the entire case rests upon the document exhibited by the parties. Now, we have to see how the document can be taken into consideration and how it is admissible in evidence. It is pertinent to mention that as per law of evidence, the oral evidence, the best evidence is the direct evidence of the documented evidence. The best evidence is the primary evidence. The contents of the document can be proved either by primary evidence of the document or by secondary evidence. It is relevant to provision of Indian Evidence Act. Well, the trial court discussed what is the section 62, 63. Your Lordship knew these sections very well. Therefore, Your Lordship kindly skip it and come to page 36. Page 36, bottom. Now, after going through the exhibit, I found that the entire case of the plaintiff and the defendant rests upon the exhibit 1, the original registered sale deed number 1399 dated 14/12/90 in the name of Radheshyam Agarwala. Exhibit 2, the original sale deed number 614 dated 17/8/94 in the name of Vishwajit Sinha. Exhibit Q is the true copy of the registered sale deed executed by Dudnath Sarkar in favor of Prafullo Dev Chaudhary. Exhibit Q is the true copy of the registered sale deed number 3273 dated 29/1963 executed by Prafullo Dev Chaudhary in favor of Rohit Das. Exhibit Q and Exhibit Q, which are exhibited by the defendant, are the secondary evidence and the contents of the original sale deed. In view of the provision of section 64 and 65 of the Indian Evidence Act, secondary evidence of a document can only be given when it's shown that one of the conditions mentioned in section 65 is fulfilled. But after careful scrutinization of the evidence of the defendant, it is found that not a single evidence has been given by the defendant showing the fulfillment of any conditions mentioned in the 65 of the Indian Evidence Act. Accordingly, I find that the Exhibit Q and Exhibit Q are inadmissible in evidence. My case is mainly based on this matter, whether Exhibit Q and Exhibit Q is the certified copy, whether these documents are inadmissible, and whether the courts below can look to the contents of the document. And both the courts below did not go through the contents of the Exhibit Q and Exhibit Q. If the Exhibit Q and Q is considered, then the plaintiff has no case. On the other hand, Exhibit 1 and Exhibit 2, the original registered sale deed, which are exhibited by the plaintiff as a primary evidence of the contents. In my considered opinion, these documents are admissible as the primary evidence and its contents are duly proved under Section 68 of the Indian Evidence Act. Now, after going through Exhibit 1 and Exhibit 2, found that the Dudnath Sarkar White Exhibit 1 sold a plot of land measuring 2/7 acres out of his share covered by Khatir number 45 tag number 121 of Village Arkapara Part 1 under Bangao Revenue Circle, corresponding to the suit land mentioned in the schedule of the plain to Radhesha Magorola on 14/12/1990 and handed over the possession. This fact is substantiated by Exhibit 4, landholding certificate issued by A.S. Bangagao in the name of Radhesha Magorola in respect to the suit land on 18/12/1991. Thereafter, this plot of land was sold to the Radhesha Magorola to Vishwajit Sinha by Exhibit 2 with delivery of possession. After the said transaction, a Kacha Patta was issued in the name of Vishwajit Sinha and his name was entered in the record of rights to prove the Exhibit 3 and Exhibit 6. On the date of Vishwajit Sinha, the name of plaintiff number 1, Krishna Sinha, was entered in the record of rights of the heirs of the deceased Vishwajit Sharma. This case is said that Exhibit 7 and Exhibit 9, the documents Exhibit 1 to Exhibit 9 are the admissible as the primary evidence, or the secondary evidence of its contents admissible under Section 65E of the Indian Evidence Act. From the discussion above, I am considered of finding that the plaintiff have been proved to avoid their right title interest of the suit land of the deceased Vishwajit Sinha. As such, the decided in affirmative in favor of the plaintiff. Then, my lord, issue number 6. Issue number 6 is more or less same. Then, my lord, the other issues are discussed and so many. Page 46. Your Lordship, to turn to page 46. Issue number Issue number 9. In view of the discussion and finding above mentioned issues, I am of the considered opinion that since the defendant could not establish the ownership of Uchit Das over the suit land, it cannot be said that Uchit Das was in constant possession of the suit land and authorized the defendant to hold the possession of the land on his behalf. Accordingly, I find that the Uchit Das was not in possession of the suit land at any point of time. Hence, the issue is decided in negative and in favor of the plaintiff. Therefore, whether the sale deed of Uchit Das, that part was not considered. Issue number 10, in view of the finding above, I am of considered opinion that this issue has become redundant. Issue number 10, Your Lordship can see. Where the suit filed by the Uchit Das in different courts in connection with the suit land were dismissed on procedural technicalities or on merit. That issue was not, though that issue was read and the evidence was late, but issue number 10 was not considered. The trial court only focus on the point that the exhibit co and exhibit co, these two certified copies are inadmissible in evidence. Therefore, the right title in interest of Uchit Das was not considered. If these two documents are considered in the admissible in evidence, then the plaintiff has no case. Because the Dudnath Sarkar sold to land to Prafullo sell to. Now the suit was decreed and against that the preferred an appeal before the appellate court. And the appellate court also appellate court did not frame any point for determination, but discussed the appeal on the issue wise. Therefore, there I simply point out some paragraph. Issue number 5 at page 68. Well, at issue number 6 at page 68, or issue 5 at 68. But relevant portion is from paragraph number 12. That is in page 70. Paragraph number 12.
Paragraph number
12.
issue number 6.
Issue number 5.
5. Okay.
Issue number it is a continuation. Issue number
Mhm.
11 and 12. 11 I am skipping over.
Okay.
Skipping over. 12
Okay.
your lordship. The plaintiff, by producing the document and examining with the witness, are able to prove that the Biswajit Sinha purchased the suit land from Radhesham Agarwal, and during his lifetime, the late Biswajit Sinha got the right title, interest, and possession over the suit land. Also mutated the name in the record of rights. After the death and legal heirs of inherited the suit land. Now the question has arisen that the plaintiff is entered into an agreement with the defendant on 7/6/2002, allowed the defendant to stay with his family and to use the thatched house as a caretaker. The said agreement exhibited by the plaintiff, Exhibit 11. PW1 proved the signature of defendant, Exhibit 1, 11.3, 11.4. The defendant as DW1 admitted his signature in Exhibit 11. The defendant alleges that the plaintiff forcefully made the agreement with him between them. He admitted that in respect to the forceful agreement, he has not informed the police to the address. My lord, the plaintiff entered into agreement with the defendant. That he will look after.
Mm.
That agreement was executed by the plaintiff by force because he had a link with some extremist people. Alleged that they forcibly entered into the agreement. The plaintiff, which was exhibited in 11. On the on being admission of the signature of the defendant, the Exhibit 11 by the defendant himself, the contents of Exhibit 11 are to be proved by the witnesses of Uppal Sharma as PW3. Exhibit 11 is duly proved. There was also agreement, power of attorney with Oshudas and the defendant. That power of attorney was not considered by both the courts. On the other hand, the defendant failed to prove that the fact not entered into an agreement. Exhibit 11 is with the plaintiff, but stated that another story in respect to the right title. In support of his statement, he adduced himself as DW1, said Ushudas as DW2, and Savitri Devi as DW3, and exhibited the document Exhibit true copy of the registered sale deed number so-and-so by Dudnath Sarkar in favor of the Prafulda Dev Chaudhary. Exhibit is the true copy of the registered sale deed number 3273 28/9/63 executed by Prafulla Chaudhary in favor of Ashwat Das. Exhibit G is the general power of attorney and the portal is executed. In respect of the evidence of the parties and the documents submitted by the both parties, the learned court below elaborately discuss the issue number 5 and provides the evidence arrived at by the direction. I find no force of the argument of the learned counsel for the appellant and below the wrongly decided and arrived at the wrong decision. So far, this current in the appellate court judgment, my lord, there is no independent finding.
No?
No independent finding of the appellate court. The appellate court only held what the trial court has, I find nothing to interfere. That is not the that should not be the judgment of the lower appellate court. Lower appellate court should discuss what is the evidence led by with whom, what he says, and the law. This there is nothing so far appellate court is concerned. Hmm? And the learned lower appellate court, though he stated in the that he will discuss the issue wise on the lordship can be issue wise discussion. I have gone with learned on both sides and the learned lower appellate court held stated that he will discuss the all issues. But the issue number 10 was not discussed. Issue number 10 is a very vital issue. Issue number 10, whether the case filed by Usudas in different court in connection with the suit plan were dismissed on procedural technicalities or on merit. Because the lower appellate court in page 67, lower appellate court after discussing the facts, in paragraph number 7, now I have discussed the appeal issue wise.
Mm.
But the issue number 10 was not discussed.
Mm.
Nothing on the so far issue number 10. Well, my whole contention before your lordship is this. The substantial question of law as framed by this court, by this court, whether the certified copy of the cell deed exhibit call and the exhibit call, the certified copy of the registered cell deed was duly exhibited by the trial court without any objection. If so, whether exhibit co and exhibit co are admissible in evidence in terms of the provision of Indian evidence. These are the two substantial questions. It is, I have exhibited exhibit co and exhibit co, which are the certified copy of the cell deed. And that those two documents were exhibited without any objection. Now I want to submit before your lordship is this. Even it is a certified copy, it is obtained from the office of the government, record maintained by the government. Therefore, when I got the certified copy of the government custody, then it can be treated as a original document. And it is admissible in evidence. Because I am not getting the certified copy from the Tahsildar office or Mozadar office. No, it is I got it from the office of the sub-registrar, and the sub-registrar maintained the register book, keeping all the cell deeds recorded in the there. Therefore, the cell deed kept in the government custody are deemed to be original copy, though it may be certified. That is the section 76, 77, 78 of the Evidence Act has stated. '76. Indian Evidence Act, my lord, old one.
Hmm.
76 certified copies of the public document. Every public officer having the custody of the public document, which may, which any person has a right or inspect, shall be the person and demand a copy of the on payment, the legal fees, therefore, together with the certificate dated on the foot of the copy of the true copy of the document or part thereof, as the case may be, which the certificate shall be dated as subscribed by such officer in his name and his official shall shall be sealed whenever the said officer is authorized by law to make the use of the seal, and such copies so certified shall be called as a certified copies. Proof of document. Such certified copies may be produced in proof of the contents of the public document as a part of the public document for the purpose of the copies. Therefore, the certified copy I have obtained from the government custody and it is sealed by the officer. Therefore, this is to be treated as the original and it has the same force as of the original sealed deed. But to this aspect, so far the exhibit co and co, there's two certified copies of two sealed deeds. I have one decision of the Supreme Court. Paragraph number 32.
Paragraph number
32.
32. Yes.
Having regard to the aforesaid circumstances and the light of the various provisions of the Evidence Acts mentioned herein before, we will firstly consider the question as to whether the appellant plaintiff succeeded in proving Exhibit A1 going through Section 65E of the original of a document of the public document within the meaning of Section 74. The secondary evidence relating its original, namely to its existence, condition, or contents, may be given or by producing the certified copy. Exhibit A1 indisputably a certified copy of the sale deed number so and so, dated 27/8/1928 of SRO Andipatti. In terms of Section 74(2) of the Evidence Act, its original falls within the definition of the original document. There is no case that it is not a certified copy manner provided under the Evidence Act. As noticed herein before, the sole objection is that the said and the which was produced Exhibit A1, only the certified copy of the sale deed, and the original of which was not produced in evidence. The hollowness and unsustainability of the said objection would be revealed on the application of the relevant provisions under the Evidence Act and the Registration Act of 19,008 and 1908. In this regard, the section 77 and 79 of the Evidence Act as extracted and assumed that the section 77 provides the produce the certified copy of the public document as the secondary evidence to prove the contents of the original. Section 79 of the provision for presumption as to the genuineness of the certified copies provided the existence of law declaring the certified copy of the document of such nature to be admissible in evidence when the when the position under the aforesaid provision taking note of the fact that the document in question is a registered shall deed, falling within the definition of public document. The question is whether there exists any law declaring the certified copy of a document admissible in evidence for the purpose of proving the contents of the original document. Subsection 5 of Section 57 of the registration is relevant for the purpose for the relevant provisions under the Act under Section 57 of the shall be admissible for the purpose of proving the contents of the original document. In this context, it is to be noted that the certified copy issued hereunder is not a copy of the original document, but a copy of the registration entry, which is itself a copy of the original document and is a public document under Section 74(2) of the Evidence Act and subsection 5 thereof. It makes it admissible in evidence for proving the contents of the original. There is no case that the foundation of letting of the secondary evidence was not laid, as noted earlier. Both the trial court and the first appellate court found that they admissible in evidence. Thus, the cumulative effect of the aforementioned section in the Evidence Act and Section 57(5) of the Registration Act would make the certified copy of the cell date number so and so of SRO Andipatti produced as Exhibit A1 admissible in evidence for the purpose of proving the contents of the said original document. That is important. Contents of the original document. When this is with the position in the light of the specific provision is referred herein under the Evidence Act, the Registration Act, we have no hesitation to hold that the finding of the High Court that the certified copy Exhibit A1 owing to the failure of production of the original or proving through the independent witness is inadmissible in evidence is legally unreasonable. It is, in the other words, the acceptance of the admissibility of the Exhibit A1 found in favor of the appellant plaintiff by the trial court and confirmed by the first appellate court was perfectly in the tune of the provisions referred herein above by the High Court, had committed an error in reversing the finding of the admissibility of the Exhibit A1. Here in this case, the certified copy was considered by the trial court and the lower appellate court, and the High Court reversed the finding, and the Supreme Court reversed the finding of the High Court and found that the certified copy is admissible in evidence, and the court is to look to the contents of the document. If, my lord, in this appeal, Exhibit K and K, both are the certified copies. Exhibit K purchased by Prafulla from Dudnat, and Exhibit K purchased by Ushut from Prafulla. If these two cell deeds are considered by the courts below, then the suit is liable to be dismissed. Therefore, your lordship kindly look to this judgment and moreover,
No, the question is whether the contents of the exhibit Ko and Kho have been proved before the
Well, we-
trial court and trial
yes,
court.
yes, we proved. We proved because we exhibited from,
No, merely exhibiting the same would not amounts to proving the contents of the same.
yes. In that case, my lord, may I read the deposition of the parties, my lord?
Yes.
আমার party deposition.
Okay.
Exhibit ক করা।
Exhibit C. C files.
C1.
C1.
Pursuit as a formal. DW1 is Pradeep Burman defendant. He exhibited the exhibit ক Prafuladev Chaudhary did not ক্রয় করা দুধনাথ সরকারের পৰা ক্রয় করা মাটির দলিল তার প্রত্যয়িত কপি পদর্শক খ অচ্যুত দাসে প্রফুল্ল চৌধুরীর পৰা ক্রয় করা জমি Your Lordship now see the cross-examination of Pradeep Burman. Össur Das'ı azındı var. But the DW defendant, he exhibited exhibit ক and exhibit খ.
Yes.
And I am reading his cross-examination. মই হাজিৰা হিচাপে কাম কৰো মই বাদীক 5 বছৰ যদি চিনি পাওঁ বিবাদী মাটি 2 বিঘা 6 লেচাই দাগ নম্বৰ ইমান পাত্তা নম্বৰ ইমান সত্য নহয় যে বিবাদীয় মাটি বাদিনীৰ স্বামী স্বৰ্গীয় বিশ্বনাথ সিংহই কিনিছিল। বাদিনীৰ স্বামীয়ে 1994 ৰেজিষ্টাৰ্ড দলিল ৰাধেশ্যাম আগৰৱালাৰ পৰা কিনিছে যদি মই গম নাপাওঁ। সত্য নহয় যে বাদী স্বামীয়ে বিবাদীৰ মাটি দখল লৈছিল। মই বঙাইগাঁৱত 23 বছৰ ধৰি আছো। তাৰ আগতে শালকোচত আছিলো। বঙাইগাঁৱত মোৰ নিজা ঘৰবাৰী নাই। এক্সিবিট 11-3 মোৰ চহী, 11-4 মোৰ চহী। 7/6/2002 তাৰিখে মোৰ বাদিনীৰ লগত জোৰ জবস্তি ধৰণে এগ্ৰিমেণ্ট কৰিছিল। জোৰ জবস্তি এগ্ৰিমেণ্ট কৰা বুলি কৈছো যদিও সেই সময়ত মই এজাহাৰ থানাত দাখিল দিয়া নাছিলো বা অন্য কোনো আইনী সাহায্য লোৱা নাছিলো। সত্য নহয় যে চুক্তিপত্ৰখন 3 বছৰৰ বাবে কৰা হৈছিল আৰু দৰকাৰ হলে মই দখল চমজাই দিব লাগিব বুলি উল্লেখ আছে আৰু অন্যথাই উচ্ছেদ কৰিব পাৰিব বুলি উল্লেখ আছে। সত্য নহয় যে 29/6/2005 তাৰিখে বাদিনীয়ে মোক বিবাদীয় মাটি এৰি দিবলৈ এখন উকিল নটিচ দিছিল। সত্য নহয় যে যোৱা 7/6/5 তাৰিখে বাদিনীয়ে বিবাদীৰ মাটিৰ গছ-গছনি চাফা কৰা লেবাৰ গৈছিল আৰু মই মানুহলৈ তেওঁক বাধা দিছিলো। তেওঁ বঙাইগাঁও থানাত এখন এজাহাৰ দিছিল। এক্সিবিট ঘ কোন তাৰিখে দিছিল উল্লেখ নাই আৰু ইয়াত বিবাদীয় মাটিৰ দাগ নম্বৰ 121 বুলি উল্লেখ আছে। সত্য নহয় যে অচ্যুত দাসে মোক বিবাদীয় মাটি দখল কৰিবলৈ দিয়া নাছিল, চোৱা চিতা কৰিবলৈহে দিছিল। অচ্যুত দাসে নালিচা মাটিৰ ক্ষেত্ৰত ডিষ্ট্ৰিক্ট জাজ বঙাইগাঁও আদালতত এটা গোচৰ কৰিছিল। উক্ত গোচৰ ডিছমিছ হৈছিল বুলি মই নাজানো। উক্ত গোচৰৰ নালিচা জমিত মোৰ কোনো অধিকাৰ নাই আৰু অচ্যুত দাসৰো কোনো অধিকাৰ নাই। সত্য নহয় যে বাদিনীয়ে 7 জুন 2002 তাৰিখৰ চুক্তিমতে বিবাদীয় মাটিত থাকিব দিছিল। বিবাদীয় মাটিৰ পূবে ৰাস্তাই দক্ষিণে বিৰাজ ৰায়, পশ্চিমে অচ্যুত দাস। তেওঁক থাকিব দিয়াৰ শালিগ্ৰাম শৰ্মাৰ বিবাদীয় মাটিৰ বাদী কৃষ্ণা সিনহাৰ নামত স্বামীৰ মৃত্যুৰ পাছত নামজাৰি হৈছে। যোৱা 17/3/5 আৰু 12/6/5 তাৰিখে বিবাদীয় মাটিত সোমাই গছ-গছনি কটা বুলি কৈছো যদিও তাৰ বাবে মই কোনো কাগজ পত্ৰ আদালতত দাখিল দিয়া নাই। আদালততো মই কোনো নথি সমগ্ৰ দাখিল দিয়া নাছিলো। সত্য নহয় যে মই বিবাদীৰ মাটিৰ পৰা উচ্ছেদযোগ্য। Therefore, your lordship can see the exhibit Q and exhibit Q was exhibited by defendant DW1. And there is not a single question cross-examination on exhibit Q and exhibit Q by the plaintiff.
No, that's all right. No question was put in cross-examination, but whether merely marking those two documents as exhibit Q and Q, it can be said that it has been proved in accordance with law.
We have examined the vendor, Ushud Das was examined.
Only it has been marked as exhibit Q and exhibit Q.
Ushud Das, who purchased the land from the proper law, he was examined. আগত আছে। Ushud Das, he was DW2. He filed the evidence on affidavit. May I read, my lord? The relevant
Yes.
question. এই গোচৰৰ বিবাদীয় জমি মই ক্ৰয় কৰা 1 বিঘা 6 লেচাৰ মাটিৰ অন্তৰ্ভুক্ত। এই মাটিৰ মূল পট্টাদাৰ আছিল দুধনাথ চৰকাৰ, পিতা বাণেশ্বৰ চৰকাৰ। জনক প্ৰফুল্ল দেৱ চৌধুৰীয়ে উক্ত দুধনাথ চৰকাৰৰ পৰা পঞ্জীয়নবদ্ধ দলিল নম্বৰ 1950 ইমান তাৰিখ যোগে ক্ৰয় কৰিছিল আৰু দখল বুজি লৈছিল। তাৰ ঠিক 5 মাহ পাছত মই আন এখন পঞ্জীয়নভুক্ত দলিল 3237 নম্বৰ যোগে মাটিখিনি প্ৰফুল্ল দেৱ চৌধুৰীৰ পৰা ক্ৰয় কৰি দখল বুজি লওঁ। সেইমতে মাটিখিনি নামজাৰি কৰি লওঁ। মই ভৱানীপুৰ উচ্চতৰ মাধ্যমিক বহুমুখী বিদ্যালয়ত শিক্ষকতা কৰি অৱসৰ লৈছো। তদুপৰি মই অনুকূল ধৰ্মৰ প্ৰচাৰক হিচাপে দীক্ষা লওঁ। মই ক্ৰয় কৰা মাটিখিনিত এটা একচেলীয়া টিনৰ ঘৰ বনাইছিলো। বিভিন্ন কামত ইয়ালৈ আহিলে এই ঘৰটোতে থাকিছিলো। মোৰ জ্যেষ্ঠ পুত্ৰ অলক প্ৰসাদ দাসে এই ঘৰটোত থাকি বঙাইগাঁও মহাবিদ্যালয়ৰ পৰা স্নাতক ডিগ্ৰী লয়। পৰৱৰ্তী সময়ত মাটিখিনি ৰক্ষণাবেক্ষণৰ কাৰণে এটা অংশত জৈনেক শালিগ্ৰাম শৰ্মা বৰ্তমান মৃত আৰু আনটো অংশত বিবাদী প্ৰদীপ বৰ্মনক থাকিবলৈ দিছিলো। এনেকেই মই যোৱা 6-3-85 তাৰিখে বিবাদীক মাটিখিনি ৰক্ষণাবেক্ষণৰ সুবিধা ৰেকৰ্ডে কৰ্তৃত্বপত্ৰ লিখিতভাৱে প্ৰদান কৰিছিলো। পিছত এখন পঞ্জীয়নবদ্ধ আমুকতাইৰনামা কৰিছিলো। প্ৰদৰ্শক গ আমুকতাইৰনামা। 1 নং বিবাদী স্বামী বিশ্বজিৎ সিংহ বৰ্তমান মৃত। বিবাদীৰ মাটিখিনি ৰাধেশ্যাম আগৰৰ পৰা ক্ৰয় কৰা বুলি কৈছে, কিন্তু এই ক্ৰয়ৰ কোনো বৈধতা নাছিল। বিশ্বজিৎ সিংহ এগৰাকী আত্মসমৰ্পণকাৰী উগ্ৰপন্থী আছিল। তেওঁৰ জীৱিত কালত শক্তি প্ৰদৰ্শনৰ জৰিয়তে বিবাদীয় মাটিখিনি নিজৰ নামত অবৈধভাৱে নামজাৰি কৰি লয় আৰু মই বঙাইগাঁও জিলাৰ ন্যায়াধীশৰ আদালতত বিশ্বজিৎ সিংহৰ বিৰুদ্ধে এটা TS 10/95 গোচৰ ৰুজু কৰো। গোচৰ চলি থকা অৱস্থাত অসুস্থ কাৰণত যোৱা 7/2/98 তাৰিখে উপস্থিত হ'ব পৰা নাছিলো। মোৰ অনুপস্থিতিৰ কাৰণত অধিবক্তা হৰেশ্বৰ দাসে আদালতত আবেদন দিছিল যদিও মহামান্য আদালতে গোচৰটো খাৰিজ কৰে। যদিও গোচৰ খাৰিজ হৈছিল, সেয়া নিতান্ত কাৰিকৰী কাৰণতহে হৈছিল। ইতিমধ্যে বিশ্বজিৎ সিংহৰ মৃত্যু হোৱাত 1 নং বাদিনে মাটিখিনি নামজাৰি কৰি লয় আৰু গোচৰটো খাৰিজ হোৱাৰ সুযোগ লৈ গ্ৰহণ কৰি বাদিনে দখল কৰাৰ দাবী কৰিব নোৱাৰে। মোৰ বাৰ্ধক্যজনিত অসুখৰ কাৰণে কিছুদিনৰ পৰা বিবাদীয় সহকনে অহা যোৱা কৰা নাই। মোৰ অনুপস্থিতিৰ সুযোগ লৈ বাদিনে কিছুমান সমাজ বিৰোধী লোকৰ জৰিয়তে শান্তিপ্ৰিয় বিবাদীৰ পৰা বলপূৰ্বকভাৱে কাগজত চহী লোৱা আৰু মই পলমকৈ অৱগত হওঁ। এনেকৈ এই ভীতি প্ৰদৰ্শনৰ জৰিয়তে উচ্ছেদৰ চেষ্টা চলায় আৰু বিফল হয়। এনেকেই গোচৰ চলি থকা সময়ত বাদিনীয়ে সমাজ বিৰোধী মানুহক জৰিয়তে শালিগ্ৰাম শৰ্মা আৰু বিবাদীক ৰোপণ কৰা গছ-গছনি কাটি দিয়ে। Is cross-examination, Your Lordship kindly see. মই 1992 চনত অৱসৰ লওঁ চাকৰিৰ পৰা। গলিয়াত মই স্থায়ীভাৱে আছো। প্ৰদীপ বৰ্মনৰ মই তাৰ বাল্যকালৰ পৰা চিনি পাওঁ। প্ৰদীপ বৰ্মন অৰিজিনেলি চালাকাছাৰ মানুহ। ধুবুৰী ডিষ্ট্ৰিক্টত তেওঁ হাজিৰা কাম কৰে। মই বিশ্বজিৎ সিংহৰ ওপৰত TS 10/95 গোচৰ কৰিছিলো ডিষ্ট্ৰিক্ট জাজ কোৰ্টত। বিশ্বজিৎ সিংহ বাদিনীৰ স্বামী। মই উক্ত গোচৰৰ এভিকশ্যন আৰু খাছ পজিশ্যনৰ বাবে কৰিছিলো। এই গোচৰ 7/2/98 তাৰিখে ডিছমিছ হয়। মিছ কেছটো ৰেষ্টৰ কৰিবৰ কাৰণে কৰিছিলো। উক্ত গোচৰ চিভিল জাজ চিনিয়ৰ ডিভিজনেল আদালতলৈ ট্ৰেন্সফাৰ হয়। পাছত উক্ত মিছ কেছটো ইমান তাৰিখে ডিছমিছ হৈছিল। তাৰ পাছত পুনৰ আণ্ডাৰ ছেকশ্যন 151 পিটিশ্যন দিওঁ। উক্ত গোচৰ ইমান তাৰিখে ডিছমিছ হয়। মই কৰা বিবাদীয় মাটি 2 কঠা 7 লেচা টোটেল 1 বিঘা 7 লেচাৰ দাগ নম্বৰ 121 আছিল। উক্ত দাগ বৰ্তমান সলনি হ'ব পাৰে। মই পাৱাৰ অফ এটৰ্নী দিছিলো বিবাদীক এক্সিবিট গ যোগে। এক্সিবিট গ 1 বিঘা 6 লেচাৰ উত্তৰে ৰোড নিজামাটি, দক্ষিণে লক্ষী মন্দিৰৰ মাটি previously কালিচৰণ বুলি উল্লেখ আছে এক্সিবিটত কোনো ডেট নাই মই 1 বিঘা 6 লেচা মাটি প্ৰফুল্ল চৌধুৰীৰ পৰা কিনিছিলো মই ডিচি অফিচত খৰ্গেশ্বৰ ৰায়ৰ ওপৰত 145 গোচৰ কৰিছিলো কি ৰায় হৈছিল মনত নাই 1 বিঘা 6 লেচা মাটিৰ পৰা 1 কঠা মাটি দখল পাবলৈ মই খৰ্গেশ্বৰ তালুকদাৰক গোচৰ কৰিছিলো আজিৰ গোচৰৰ মাটিৰ উত্তৰে ধীৰাজ ৰায় দক্ষিণে লক্ষ্মী মন্দিৰ পূবে গাঁৱলীয়া ৰাস্তা পশ্চিমে অচ্যুতাচ অৰ্থাৎ নিজা বিবাদীয় মাটি বিশ্বজিৎ সিংহই বাদিনী হিচাপে ৰেজিষ্টাৰ যোগে ৰাধেশ্যাম আগৰৱালাৰ পৰা খৰিদ কৰা লৈছিল আৰু কিছুদিনৰ বাবে যোৱা 8/6/2002 তাৰিখে বাদিনীৰ লগত বিবাদীয় মাটি চোৱা চিতা কৰাৰ বাবে এগ্ৰিমেণ্ট হৈছিল যদিও মই নাজানো বিবাদীয় মাটি 3 বছৰ থকাৰ বাবে এগ্ৰিমেণ্ট এই গোচৰ মই পক্ষভুক্ত হ'বলৈ কোনো দৰখাস্ত দিয়া নাই TS 10/95 মই ৰাধেশ্যাম আগৰৱালাক প্ৰাৰ্থী কৰা নাছিলো প্ৰদীপ বৰ্মন বিবাদীয় মাটিত মই অথৰিটি হিচাপে বহি আছে সত্য নহয় যে প্ৰদীপ বৰ্মনক মই অথৰিটি দিয়া নাই সত্য নহয় যে বিবাদীয় মাটিত মাটি আছে তেওঁ দখল লোৱাৰ হকদাৰ সত্য নহয় যে TS মই ডিছমিছৰ বাবে প্ৰদীপ বৰ্মনক দিয়া পাৱাৰ অফ এটৰ্নি বৰ্তমান গোচৰত নাখাতে এক্সিবিট গ উল্লেখিত 1 বিঘা 6 লেচাৰ বিৱৰণ মই দিয়া নাই সত্য নহয় যে প্ৰদীপ বৰ্মন উচ্ছেদযোগ্য
Yes.
Well, the citation I have referred, paragraph number 32. Your Lordship, last portion of that paragraph. When this be the position, Your Lordship got 1, 2, 3, 4, 5, 6, 7, 8, 10 line from the bottom of that paragraph. When this has been the position in the light of the specific provision referred herein before under the Evidence Act and the Registration Act, we have no hesitation to hold that the finding of the High Court that the certified copy exhibit A1 owing to the failure in the production of the original and proving through the independent witness is admissible in evidence is legally unsustainable. Therefore, in our case, the main defendant PW1, like DW1, he exhibited the exhibit co and exhibit co. And finding the High Court exhibit failure to production of the original proving the independent witness. That exhibit co and co produced by the defendant, and that the cell deed was executed and registered. That was proved by the DW2 or Suddhas. Therefore, Osudas was examined, the full government defendant was examined, he exhibited the cell deeds. And the Osudas, he, he stated that yes, this is my cell deed. Therefore, the independent witness is inadmissible. It is legally unsustainable. Therefore, we have exhibited and we have proved that certified copy. In other words, the acceptance of the admissibility of Exhibit A1 found in favor of the appellant plaintiffs by the trial court and confirmed against them. Therefore, the certified copy is can be taken, it is admissible in evidence.
Okay,
Reply at 2 o'clock.
2 o'clock.
Yes, my lord. My lord, the in evidence of PW1, he has stated that the exhibit 4 মতে গুচৰীয়া দাগ 121 মুঠমাটি 1 বিঘা 1 কঠা 1 লেচা। PW1. Across examination. Peaceful domination. Dhiren Rai Osudas এক দখলদাৰ মাটিবোৰৰ দখল বুলি মই নাজানো। দুধনাথ চৰকাৰ পক্ষভুক্ত এক্সিবিট 4 মতে গুচৰীয়া দাগ অৰ্থাৎ 121 নম্বৰৰ দাগৰ মুঠ মাটি 1 বিঘা 1 কঠা 1 লেচা। এই দাগৰ একে মাটিত মুঠ আছে 15 বিঘা 4 কঠা 10 লেচা। এই 121 নম্বৰ দাগ, it has only 1 biga, 1 kata, 1 lesa. She has stated in her evidence in evidence. As well as in Exhibit 6. And the land sold to the Osudas is 1 biga, 6 lesa. Now there only remains 15 lesas of land in the dag number 121. In dag number 121, she has stated that the 1 biga, 1 kata, 1 lesa, a 121. Osudas purchased land from Profulla 1 biga 6 lesa. If 1 biga 6 lesa is deducted in the said dag 121, then only 50 lesas will left.
2 kata 7 lesot বিক্ৰী কৰিব নোৱাৰি।
And 2 kata 7 lesas of land, as they stated, they have no right to sell that land.
তাৰ মাটি নাই। আমাৰ প্লেনটিফৰ 2 কটা 7 lesot মাটি নাই মতলব।
Yes.
আজি তাতে Osudas মাটিটো ল'ব পাৰিছে।
মানে what did the defendant where the defendant fears that the plaintiff now want to grab the land of the Osudas through the defendant. Because if these two cell deeds are considered by the trial court and the appellate court, then we have a very good case. And your lordship can see.
কাৰণ মাটি নাই।
That be your Now the this appeal is directed against concurrent finding of fact immediately. Both the courts have reported finding that the plaintiff has died. And the defendant who has not claimed any title, he is saying that he is a permissive occupier, but not under me, but under one Achyut Chandra Das. That is the case of the defendant. He is not claiming title. Now, both the courts have found that he is a trespasser because he was there for 3 years. He was given permission to stay there for three years, and that too on the basis of an agreement. Now, the two substantial questions of law framed are whether the certified copy of exhibit core, deed number so and so, dated so and so, and exhibit core so and so, were duly exhibited without any objection. In my humble submission, this is not a substantial question of law. This is whether duly exhibited without any objection. Assuming that it is exhibited without objection, the law is very clear that if it is not admissible in evidence for non-compliance of the conditions mentioned in section 365 of the Evidence Act for tendering a certified copy of a document, then it will not be admissible in evidence. So in that way, the matter matters number 1, substantial question of law. My lord. My lord. I'll come to that, my lord. I've understood. I'll reply to that also. Second, my lord. Second is, my lord, if so, whether exhibit core and core are admissible in evidence in terms of the provisions of the Indian Evidence Act. Slightly well, no specific provision as such has been mentioned. Well, I'll not take your lordship to the detailed facts ever meant in the plaint, but I'll just cut it short. I'll argue to the point. The plaintiff's case is that I am the owner of the plot of land on the basis of a sale deed, which is exhibit 2, executed by Radhesham Agarwala on 17/9/1994. And the plaintiff has proved the original certified copy. And Radhesham Agarwala purchased the land on 14/12/1990 from Dudnath Sarkar, which also has been proved in original as exhibit 1. There is absolutely no objection to this same statement, exhibit 1 and exhibit 2. From Dudnath Sarkar. And these are all from the findings of the learned trial court and the government made the plaint and the evidence. I'm not taking a lordship to those things, but these are all admitted position. So far as the defendant is concerned, defendant's case is that they also admit, in the written statement, that original owner was Dudnath Sarkar. This much is admitted. If your lordship desires, I can show also. What they are saying is, original sale owner was Dudnath Sarkar. From him, one Prafulla Dev Chaudhary purchased by exhibit Khaw on 26/4/1969. And from Prafulla Dev Chaudhary, one Achyut Das purchased by exhibit Khaw on 28/9/1969. And they are relying on these two documents. I'll come to that a little later. I'm just giving the background. So far as plaintiff is concerned, plaintiff's case is that original owner is Dudnath Sarkar. From him, Radhesham Agarwal purchased, and from him, plaintiff's predecessor, that is her husband, purchased. There is absolutely no objection to this document. They could not demolish this document or the government made in the plaint. This is an admitted fact. Now, in order to disprove our case, they have come with a different story. They say that original owner was Dudnath Sarkar, and from him Prafulla Dev Chaudhary purchased by virtue of exhibit Khaw, and from Prafulla Dev Chaudhary, Achyut Das purchased by exhibit Khaw. This is their story. And before I take your lordship to these aspects, one more aspect may be relevant. In paragraph 7 of our complaint, we have said that from 2002, the defendant was allowed to or permitted to stay there. I don't know if your lordship. Paragraph 7, madam. From 7/6/2002. That is their case, my lordship will see whether they have been able to establish their case or not. Paragraph 7 at page 6 of this memo of appeal. Somehow this memo of appeal is, my lord, it's with them, it's telling with us, our copy also. Because if the page numbers do not tell him, it's difficult to refer to the specific pages and paragraphs. Memo of appeals. Para 7 at page 6. Yes, if the lordship refers to this memo of appeal, then it becomes convenient. Paragraph 6, lordship will find the plaintiff says that on 7/6/2002, the defendant approached the plaintiff to allow him to live with the family in the thatched house over the land temporarily, since the defendant is very much familiar with the family of the plaintiff since long. And the plaintiff number 1 permitted the defendant to live in the land and to use the thatched house as a caretaker. Plaintiff number 1 agreed to the request and entered into an agreement with the defendant on 7/6/2002, along with the defendant to stay with the family in the said land for 3 years, who thereafter occupied the land, and he has been living there till filing of the suit as caretaker. This is our case. And we said that after 3 years, when we asked to vacate, you did not vacate, you have become a trespasser. That is the case of the plaintiff. Title is there and you are a trespasser. To this, the stand of the defendant at page 13, lordship will find at para 14, while responding to this paragraph of the plaintiff, my lord, what they say in the written statement, my lord. Running page will be 13, man. Para 14 at the bottom. That as regards the averment made in para 7 of the plaintiff, it is wholly denied that the defendant had approached the plaintiff to allow him with family in the said thatched house temporarily. In fact, this is his stand, my lord. In fact, the permission was accorded by said Achyut Chandra Das, the original owner of the house, to the defendant in the land and to use the thatched house. The plaintiff never agreed to the defendant for staying in the said house over the land. Indeed, during the pendency of the suit, a few unknown persons came before the defendant and took some signature of him forcibly on some blank papers and threatened him not to disclose other person else. He would have to face dire consequences. The defendant is a poor person doing day laboring and had been living hand to mouth with his family. He did not disclose the matter to any person due to fear of death. And my lord, one more thing I have to show, my lord, page 15. Added to this, he said one more thing. He says, and he is under Achyut Das by virtue of a power of attorney. That I am showing, my lord, to your lordship. Page 15 at the bottom, my lord. Line number maybe 8, 9, my lord. On 6/3/1985, lordship is good, my lord. The said Achyut Das issued a letter of authority in an unregistered form, allowing the defendant to stay upon the land in question as well as to stay at his house and to look after the same. Later, on 18/4/2005, he once again executed a general power of attorney in favor of the defendant, confirming his earlier declaration in regard to the suit land. From the above, it is clear that as a rightful person, defendant has been possessing the suit land as well as the house. He cannot be termed as the illegal civil trespasser and unauthorized occupant. This is his stand. So he is denying the fact that he is a permissive occupier under me. And he's taking a stand that one document I have signed, and that has been converted into a agreement, which we are saying an agreement between him, allowing him to stay there for 3 years. And in addition to that, he's saying that in fact it is Achyut Das who was the original owner, permitted him to stay there initially on a particular date on 2005, 1985, and later on the basis of a power of attorney on 18/4/2005. This is his standby. Now, I'll take your lordship to the finding of recorded by the learned trial court on issue number 5 first, then I'll make my submission. Lordship will kindly turn to page 30. Because issues are at page 24, my lord. And page 25, lordship will find issue number 5 is whether the plaintiff has right, title, and interest over the suit land mentioned in the plaintiff. At page 25, my lord. Discussion starts on issue number 5 at page 30. I'll not read the entire matter, 2-3 paragraphs may be necessary. May I read, madam? In order to decide the issue, we have to see first the contentions of the plaintiff. Plaintiff side in their pleading and during the argument of London Council stated that the plaintiff has a right and interest over the suit land as the legal heirs of deceased husband, father, late Biswajit Sinha, who purchased a plot of land measuring 2 kata 7 ledgers covered by so from one Sri Radheshyam Agrawala through registered sale deed number so dated so, which is mentioned as suit land in the schedule. The plaintiff further contended that land was originally belonged to one Sri Dudnath Sarkar, from whom it was purchased by one Sri Radheshyam Agrawala, and from him the deceased husband, father of the plaintiff, purchased the same and took possession over it. To support and establish her claim, the plaintiff number 1 adduced evidence of herself as PW1, Sri Radheshyam Agrawala as PW2, Utpal Sharma as PW3, and exhibited Exhibit 1, the original registered sale deed number so dated 14/11/1990 in the name of Radheshyam Agrawala. Exhibit 2, the original registered sale deed number 614 dated 17/8/1994 in the name of Biswajit Sinha, that is her husband, my lord. Exhibit 3, the Kacha Patta of the suit land dated 16/10/1995 issued by the ASO Bongaigaon in the name of Biswajit Sinha. Exhibit 4, the land holding certificate issued by ASO Bongaigaon in the name of Sri Radheshyam Agrawala in respect to the suit land on 18/12/91. Exhibit 5, non-encumbrance certificate issued by the sub-registrar of Bayapuri in the name of Radheshyam Agrawala in the name of Radheshyam in the respect to the suit land on 20th April 1992. Exhibit 6, certificate copy of Jamabandi showing the suit land in the name of Biswajit Sinha. Exhibit 7, the certificate holding land holding certificate issued by the ASO Bongaigaon in the name of Srimati Krishna Sinha in respect of the suit land on 15/6/2005. Exhibit 8. So all these documents have been proved in original. Now, if your lordship kindly see the bottom paragraph of this page, the plaintiff's case has been challenged by the defendant and alleging that plaintiffs have no right, title, interest, and possession of the suit land, as the actual owner of the suit land is one Sri Achyut Das. The defendant admitting the fact that say suit land originally belonged to Dudnath Sarkar. This is why they have admitted. So Dudnath Sarkar submitted that original owner long back from the alleged transaction by the plaintiff with Sri Radheshyam Agrawala in the year 1969 sold a major portion of this land, of which the suit land is a part, to one Sri Prafulla Dev Chaudhary, and from Prafulla Dev Chaudhary, the land was purchased by Sri Achyut Chandra Das in the same year. As per the defendant, the actual owner of the possession of this schedule mentioned land is Sri Achyut Das, who purchased a plot of land measuring so by registered in so. Next paragraph, my lord. In support of his case, defendant examined DW1 Sri Achyut Das as DW2, Srimati Savitri Devi as DW3, and exhibited some documents. Exhibit called the true copy of the registered sale deed dated so executed by Sri Dudnath Sarkar in favor of Sri Prafulla Dev Chaudhary. Exhibit called the true copy of the registered sale deed dated so executed by Prafulla Dev Chaudhary in favor of Sri Achyut Das. Exhibit Gaur, the general power of attorney given by Sri Achyut Das in the name of defendant. Exhibit Gaur, the certified copy of the voter list settlement. These are not relevant. Now, my lord, discussion starts from page 33. just above the last subparagraph, my lord, it is mentioned. Now we have to see that how far the documents can be taken into consideration and how far they are admissible in evidence. Now, next page, my lord, will find 62 of the evidence act is mentioned about primary evidence, 63 secondary evidence. Then next page 64, then 65 mentioned. Now the page 36, my lord, at the bottom the findings start. How this exhibit 4 and 5 were said to be inadmissible evidence. Page 36 at the bottom, my lord. Now, after going through the exhibits, I found that the entire case of the plaintiff and the defendant rests on exhibit 1, the original registered sale deed number so-and-so dated so-and-so in the name of Sri Radheshyam Agarwala. Exhibit 2, original registered sale deed number so-and-so in the name of Mrs. Sinha. Exhibit called the true copy of the registered sale deed number so-and-so dated so-and-so executed by Sri Dudnath Sarkar in favor of Prafulla Dev Chaudhary. Exhibit called the true copy of the registered sale deed number so-and-so dated so-and-so executed by Prafulla Dev Chaudhary in favor of Das. Here, exhibit co and co which are exhibited by defendant are secondary evidence of the contents of the original sale deed. In view of the provisions of section 64 and 65 of the Indian Evidence Act, secondary evidence of a document can only be given when it is shown that any one of the conditions mentioned in section 65 is fulfilled. But after careful scrutiny of the evidence of the defendant, it is found that not a single evidence has been given on behalf of the defendant showing fulfillment of any of the conditions mentioned in section 65 of the Evidence Act. Accordingly, I find that exhibit co and co are inadmissible in evidence. And regarding the, my lord, this is the finding with regard to the title of the plaintiff. That is why, my lord, at page 38 at the bottom, my lord, the learned trial court has come to a finding that from the discussions made above, I am of the considered finding that plaintiff have been able to prove their right title interest over the suit land as legal heirs of deceased Biswajit Singh. My lord, in order to possibly meet the plea taken by the plaintiff that he is the owner of the land, the suit land, on the basis of the two registered sale deeds which he proved in original, the defendant has taken a plea that, see, I am a permissive occupier, but not under you, but under Achyut Das, who is the owner by virtue of exhibit co and co, two sale deeds. Now, co and co has been held by the learned trial court to be inadmissible in evidence for non-compliance of the conditions, any of the conditions mentioned in section 65. In addition to that matter, my submission will be that a submission has been made on behalf of the appellant. Let's see, in terms of section 70, 6, the certified copies of public documents. We are not concerned with any public document here. And there are number of judgments showing that a certified copy of a sale deed is not a public document. And for that, possibly I need not show any judgment. There are a number of judgments that certified copy of the sale deed is not a public document. This is my learned also will agree. So section 76 is not possibly my relevant in our case. What is relevant is, my lord, section 64. 64 says that, so I'm sorry, my lord, section 62. Section 62 of the Evidence Act says, my lord, that I'll first show section 61. Doctor, can you pardon me? 61 says proof of contents of documents. The contents of documents may be proved either by primary or secondary evidence. Now, 62 deals with primary evidence. We are not concerned because exhibit co and co are secondary evidence. 63 defines secondary evidence. Secondary evidence means and includes certified copies given under the provisions hereinafter contained. Well, admissibility of secondary evidence is not in dispute and not a question here. I am also admitting it is an accepted proposition of law that secondary evidence is also admissible in evidence. But what the problem is, whether for proving a document or contents of a document which is secondary evidence, the conditions of section 65 are complied with or not is the question in our case. Whether my learned friend, my lord, with all respect, I'll submit, has cited some judgment showing that certified copy is admissible in evidence, but there is no dispute with the proposition that secondary evidence is admissible in evidence, provided in a case where the question is whether the conditions mentioned in section 65 are fulfilled or not in order to accept the secondary evidence as admissible. That is the question in our case. Now, in our case, my lord, the London trial court has come to a very clear finding that you have not fulfilled any of the conditions. So therefore, the question is, if the defendant fails to prove any of the conditions mentioned in section 65, whether those documents can be said to be admissible in evidence or not, is the question, my lord. 65 says, my lord, cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or contents of a document in the following cases: when original is shown or appears to be in possession or power of the person against whom the document is sought to be proved, or of any person out of reach, or of not subject to the process of the court, or of any person legally bound to produce it, and when, after the notice mentioned in section 66, such person doesn't produce it. Then C is more relevant, my lord. C says when the original has been destroyed or lost, or when the party offering evidence of its contents cannot, for any other reason not arising from his own default or neglect, produce it in reasonable time. And here they have produced the two things are there, my lord. They have produced the certified copy, but the certified copy did not come from Achyut Das. These two certified copies, your lordship will find, have been proved by DW1, who is the defendant. He is not a party to the document. The appellant before your lordship, who was the defendant there, is not a party to exhibit co or co both. And he has proved exhibit co and co, not DW2. DW2 is Achyut Das. In fact, Achyut Das is the neighbor. He has got a plot of land adjacent to this land. It's interesting, my lord. The defendant says, I am a permissive occupier under the neighbor. Neighbor doesn't come forward, and neighbor in his cross-examination says that I have not implicated myself in this case as a defendant. So he has got no objection if the plaintiff gets title over the property. This is his admission in the cross-examination, DW2. Achyut Das has been examined by the defendant as DW2. So, my lord, in this case, when the documents comes from the custody of DW2, who is not a party to this, DW1, sorry, who is not a party to this document, that itself shows, my lord, this is not admissible in evidence, number one. Number two, my lord, what is more interesting is, for any reason, if they have been able to fulfill the conditions of section 65, and the documents were found to be admissible in evidence, even then, it will not help them for the simple reason that the Achyut Das, my lord, who is examined as DW2, is claimed by defendant and present appellant before your lordship to be the owner of the land on the basis of exhibit co and co. But same Achyut Das, my lord, in fact, earlier filed a suit against the present plaintiff. And that suit was dismissed for default. And they have preferred revision, etc. All those things were dismissed. That your lordship will find at page 23 of this memo of appeal. Yes. My lord, my lord, but then, my lord, if it is dismissed for default and if it is not restored, uh, they can't file any fresh suit again. So title is gone. So far as Achyutas is concerned. Achyutas is not coming forward to claim title over the land. Defendant number 1 is saying that Achyutas is the owner. Achyutas is a person involved in the case in the sense that he is a witness. He knows about this case. Still, he doesn't claim. Even defendant number 1 doesn't file any counterclaim saying that, see, you are not the owner. It is the defendant, Achyutas, who is the owner, and I am a tenant and or caretaker of Achyutas. That is not there. That counterclaim is not there, neither by Achyutas nor by defendant. I'll just point out that particular paragraph, page 23, Lord, may kindly see of this memo of appeal. Moreover, the defendant stated that the allegation of the plaintiff is false and baseless. I'm sorry, madam, page 23 on the bottom. I'm sorry, madam, page 23 at the bottom. On being allowed, if Lordship has got, madam, page 23 at the bottom. On being allowed by the court, the plaintiffs amended the plaint by incorporating the fact that Achyutas filed a title suit in respect of the suit land against the plaintiffs, being title suit number 10 of 1995, before the Court of Honorable District Judge Bongaigaon, which was dismissed on 7/2/1998 for default. Thereafter, Achyutas filed a revision under Order 9, Rule 9, read with 151 CPC, being Miss case number so and so, before the Court of Honorable District Judge Bongaigaon. The said major case was transferred to the learned civil judge Bongaigaon, being renumbered as Miss case number so and so, which was dismissed on 18/8/99 for non-production of witnesses by the petitioner. Again, Achyutas filed a petition under section 151 of CPC, being number so and so, before the Honorable Civil Judge Bongaigaon, which was also dismissed on 13/9/2001. In view of the above fact, the plaintiff stated that the Sri Achyutas could not establish his right title, interest, and possession over the suit land. In answer to the amended pleadings of the plaintiff, the defendant, in the form of additional written statement, the defendant stated that the cases of Achyutas were dismissed only on the ground of procedural technicalities, not on merit. Moreover, Sri Achyutas is in continuous possession of the suit land through his agents. This is his plea. Now, as regards the permissive occupation under Achyutas, that discussion has started from page 38 under issue number 6, my lord. Issue number 6, my lord, deals with whether the defendant is liable to be evicted from the suit land and the plaintiff is entitled to khas possession of the suit land as mentioned in the suit. Issue number 6 at page 38 is relevant. From the pleadings of the parties and evidence on record, it is clear that defendant is now occupying the suit land. Defendant is stating that he is in possession of the suit land since 6/3/85 as authorized by Sri Achyutas through Exhibit Go, a certified copy of General Power of Attorney on so and so. On the other hand, the plaintiff submitted that the defendant had been in possession of the suit land since 7/6/2002 as a caretaker of the land by Exhibit 11, the deed of agreement between the plaintiff number 1 and defendant, executed on 7/6/2002. And since 7/6/2005 illegally. Defendant alleged that during the pendency of the suit, some persons took his signature forcibly in some blank papers, and those papers were converted into Exhibit 11 because there was no such agreement between him and plaintiff number 1 as stated by the plaintiffs. Now, after going through the submissions of the learned counsel in this regard and the depositions along with the exhibits, I find that defendant is defending his possession of on the basis of Exhibit Go given to him by Sri Achyutas, perused Exhibit Go, which reveals that the same is a certified copy of the General Power of Attorney, which is inadmissible in evidence as per the law laid down under section 61 to 65 of the Indian Evidence Act, as narrated above, issue number 5. Rather, it is irrelevant, well, this is important, irrelevant that whether Exhibit Go is admissible or not, because the person on the strength of whose alleged right the defendant is holding his possession over the suit land, the defendant has failed to prove his right title, interest, and possession of the suit land. Further, it is alleged that Exhibit 11 was forcefully extracted from the defendant, but the defendant did not lodge any police complaint against the illegal act. I find hard to believe the statement of the defendant because he alleged that some unknown persons took forcibly his signature on some blank papers. But perusal of Exhibit 11 reveals that of the 2 pages, one is a stamp paper of 20 and the other is a general cartridge paper. Further, Exhibit 11 is the original copy and the contents are proved by one witness, Utpal Sharma, SPW3. Accordingly, it can be presumed that there was an agreement between the parties regarding the suit land, whereby the defendant was allowed by the plaintiff number 1 to stay in the suit land along with his family as the caretaker of the suit land for a period of 3 years from 7/6/2002. That after expiring the state period on 7/6/2005, the defendant is occupying the suit land illegally on being asked to vacate the said land, verbally and through legal notice admitted to have been received by the defendant by plaintiff number 1. Accordingly, as the defendant is occupying the suit land illegally since 7/6/2005, it is essential for the ends of justice to restore the possession of the suit land to the plaintiffs in view of the fact that the plaintiff have been successfully proved their right, title, and interest over the suit land in issue number 5 by removing the defendants therefrom. This is the case. So, my submission before Lordship will be that plaintiff has proved its title. Defendant has admitted the right title of the person from whom the plaintiff has purchased, that is Dudnath Sarkar. But when defendant, my lord, sets up a different case or different story, that yes, original owner is Dudnath Sarkar, but from him, it was Prafulla Dutt Chaudhary who purchased and from him Achyutas purchased. First of all, Exhibit Co and Co being, my lord, certified copy and there being no foundation for filling up the one of the conditions of section 65. The Exhibit Co and Co were held to be not admissible in evidence. In that view of the matter, what remains is to be seen is as to what is the status of defendant in respect to the suit land. He is a trespasser, my lord. And he is claiming that Achyutas is the owner. Achyutas' ownership could not be established by him or by Achyutas himself. And Achyutas is aware of the suit. He comes as a witness. And he does not want to establish his right. He says, I have not implicated myself as a defendant in this case. So he is giving up. So if he gives up, my lord, then the status of the defendant becomes that of a trespasser only and nothing else. And this finding of fact recorded by the trial court has been affirmed by the learned appellate court. Trial court has 2 judgments to that of salvation. I am relying on 3 judgments. One is a very recent judgment by this court, where this court has taken into consideration all the past Supreme Court judgments on the question as to whether finding of fact recorded by the learned trial court and affirmed by the first appellate court can be interfered with by the High Court in exercise of power under section 100 of the Civil Procedure Code. And then, my lord, and then there are 2 other judgments of the Supreme Court, my lord. One is 2013, volume 2 SCC, madam. Page 114. U3 versus U Srinivasan. 2013, volume 2 SCC, page 114. And I'm relying on paragraph 17, madam. Recently, in H. Siddiqui versus so and so, while dealing with this section 65 of the Evidence Act, this court opined that though the said provision permits the parties to adduce secondary evidence, yet such a course is subject to a large number of limitations. In a case where the original documents are not produced at any time, nor has any factual foundation been laid for giving secondary evidence, it is not permissible for the court to allow a party to adduce secondary evidence. Thus, secondary evidence relating to the contents of a document is inadmissible until the non-production of original is accounted for so as to bring it within one or other of the cases provided for in the section. The secondary evidence must be authenticated by foundational evidence that the alleged copy is in fact a true copy of the original. It has been further held that mere admission of a document, which your lordship was saying, my lord, it was further mentioned, held that mere admission of a document in evidence does not amount to its proof. Therefore, it is the obligation of the court to decide the question of admissibility of a document in secondary evidence before making endorsement thereon. Then, my lord, I am relying on the other judgment of 2016. There, my lord, if your lordship kindly goes to paragraph 13. As a general rule, documents are proved by leading primary evidence. Section 64 of the Evidence Act provides that documents must be proved by the primary evidence except in cases mentioned in Section 65 of the Evidence Act. In the absence of primary evidence, documents can be proved by secondary evidence as contemplated under Section 63 of the Act, which reads and so and so. Then para 14, my lord. Section 65 of the Act deals with the circumstances under which secondary evidence relating to documents may be given to prove the existence, condition, or contents of the documents. For the better appreciation, Section 65 of the Act is quoted below. Then, my lord, para 15. The preconditions for leading secondary evidence are that such original documents could not be produced by the party relying upon such documents in spite of best efforts, unable to produce the same, which is beyond their control. The party sought to produce secondary evidence must establish for the non-production of primary evidence, unless it is established that the original document is lost or destroyed, or is being deliberately withheld by the party in respect of that document sought to be used. Secondary evidence in respect of the document cannot be accepted. And in our case, the first document, that is Exhibit Co, is in favor of the one Mr. Chaudhary. Second document is executed by that Chaudhary in favor of Achyut Das. Achyut Das has not proved this document. It is the defendant who has proved this document. And secondly, my lord, if Achyut Das is aware of this suit, if the defendant is in touch with Achyut Das, he could have brought the original from Achyut Das. So, otherwise also, none of the conditions of Section 65 are available to him actually. It says if the person is not available, if the document is not available, or if the document is in the possession of the other side, or if the person who is in possession of the document is not producing that document. These are the conditions, my lord. These conditions, even otherwise, cannot be fulfilled. Although the Supreme Court says that if you have to lay the foundational fact first in order to be eligible to prove a document through secondary evidence. And lastly, my lord, the judgment which I have given of our High Court, and it was and it is 2025 SCC online, Gauhati 2377. Pinaki Prasad Biswas versus Mahindra Danda. And your lordship passed the judgment on 24th of April 2025, very recently. My lord, discussion start from paragraph 9. And in paragraph 12, my lord, lordship has recorded that the requirement of order 41 will 31. And then with regard to the finding of fact and the power to interfere under section 100, my lord, para 14.1 is relevant, my lord. This proposition of law is also well settled in the case of Commissioner versus Hindu Religious and Charitable Endowments versus so-and-so, 2005 9 SCC 232, where it was held that the High Court has no jurisdiction in second appeal to interfere with findings of fact. Then in State of Kerala versus so-and-so, it had reiterated the same principle that a High Court is not justified in interfering with the concurrent findings of fact. Then my lord, court observed that in doing so, High Court has gone beyond the scope of section 100 of the Code of Civil Procedure. Thereafter, in so-and-so, 2005 10 SCC 553, this court observed that High Court was not justified in interfering with the concurrent finding of fact. It was also observed that it is well settled that even if the first appellate court commits an error in recording a finding of fact, that itself will not be a ground for the High Court to upset the same. Again, in Harjit Singh so-and-so, this on court with anguish, the findings of mentioned that findings of fact arrived at by the first appellate court. In the same case, the findings of trial court and the lower appellate court regarding readiness and willingness to perform their part of the contract was set aside by the High Court in its jurisdiction under section 100. Then, setting aside the judgment of the High Court, it had been observed that the High Court was not justified in interfering with the concurrent findings of fact arrived at by the court's field.
Marude, I have the ruling I have submitted before your lordship.
Yes.
That from paragraph number 32 I referred earlier. From paragraph number 22, you lordship kindly see.
Right.
22. Cases where the secondary evidence relating to document may be given. Secondary evidence may be given on conditional. E. When the original is a public document within the meaning of section 74. Our case is 74. And if you also go through the other paragraphs of 32, it all discuss the
A term fixed at 2 p.m.
This 2016 judgment, my lord, paragraph 20 also I am relying on lordship, kindly mentioned, paragraph 20. There it speaks about the, my lord, probative value of the document. Exhibit 4, even if proved, my lord, I said they have no probative value in view of accusers failing to establish his title. Paragraph 20, my lord. Applies to examine the probative value of the document produced in the court. Apply.
Item fixed at 2 p.m. Item number 3 of court number 13.
Yeah, my lord, petitioner is the petitioner in person, my lord, so we could not serve that affidavit in opposition that is ready, my lord. So today I am going to serve a copy, my lord. Let the matters fix some other day, my lord.
Lordship,
Petitioner in person, my lord, there is no one to take that copy, my lord. and he is from Chandigarh.
Lordship, on last order also, same thing they have said, and as per order of the Honorable Court, I have given the ID also to their junior.
But mail ID is not, because I'm today, affidavit is ready, I'm going to serve my lord. Next week, my lord. No,
I'm going back to my, with my brother in Tezpur to stay over there. Sir, so one submission is there, sir. Sir, submission is like my submission is not for the not required their objections, because my submission is whatever the trial court has said, that has already been ordered by this High Court in 2010. And second application was also similar to is follow that, and that is my question is between trial court and me only. Judgment of the trial court, judgment of the High Court, and second application there. It is nothing to concern with their objections. 5-6 times they have taken their adjournment for giving the objections. This is not just one time, Lordship. Or my case is Lordship 43 years old since the contract was concluded in Tezpur of MES. This 4 decades, more than 4 decades is going on. I was there about 28 years now. I was age was 28. Now I am 73, sir. Still it is pending. Kindly, one only, it will take 2 minutes only, two main things. I'm coming to page number 7, Lordship. In paragraph number 10, Lordship, my application. Page number 7, Lordship, of my application. Para 10th. I'm reading, Lordship. That the applicant humbly submits that both the 2 applications were filed before the lower court. Both the application before civil court for condemnation and restoration of the case were filed bearing Miss J number 11 2006 and 12 2006. Out of which the Miss case to 11 2006 was allowed in FA of 28 of 2010 dated 27/7/2017 by the Honorable High Court, after considering the sufficient causes as explained by the applicant. But the second application, 12/2006, which was almost of the same ground as decided by the Honorable High Court in FAO 28 of 2010, was not taken into consideration for restoration of the petition under order rule 9, Lordship. Then I'm coming, sir. That's what the order of the High Court, Honorable High Court, page number 10, Lordship. The order of High Court. Page number 10, para number 2. This says this appeal has been filed under section 43 and so against the order of dated 18/8 passed by Zone 11/26 of the civil judge, thereby rejecting the application for continuation of delay, consequently dismissing the petition under order 9, rule 9 CPC for setting aside the date of order dated 25/3. It has already been decided. The trial court which is rejected my application, this has already been decided with this Honorable High Court in 2010 of the same ground. Again they say, nay, you go and take the order of it. Well, sir, it is already decided. And moreover, Lordship, I mean, in page number, the last High Court order, page number 12, it is very important, Lordship, in para 9. Conclusion para. Say, in the view of the matter, the appeal is allowed and the order of the dismissal of the suit dated so and so is set aside. However, the delay has certainly caused some inconvenience to both other party, which is also required to be taken care of it. End of the justice, keeping in view of the above aspects, the petitioner is directed to pay a cost of rupees 5,000. The learned trial court shall proceed with the suit subject to the payment of the said costs. Proceed to the suit. suit is of 3/99, जो arbitration suit is pending. This is direction to proceed it suit. But their lordship, they are not proceeding with that suit. 3/99, under which we have requested the lower court. At that time, lower court was jurisdiction to appoint arbitrator in arbitration 1940, sir, for a substitute appointment of arbitrator. Moreover, lordship, they are filing objections, and otherwise, this is the letter of the Union of India. They say my claim is also there. When their claim is there, my claim is there, the arbitrator has to decide it. Civil court has no jurisdiction on that. So what for the objection they are filing? Either they say they don't claim on me. Only mixing the issue that here and there.
And we might take it on last week of April, madam. Short date may be given, madam.
So many dates we are paying losses.
Because first of all, madam, could not start because no one is taking that on behalf of him, madam, here.
So,
No
lordship, there is, if they will not claim on me, then what is the giving of objection? Because that has to decide by the arbitrator. Why are they? If their objection to on me for consideration of delay, it means they do not want to appoint arbitrator. Then why are they? But that's also not main issue. See. Lordship, then I'll the may kindly be on 28th of this month. 28th. Yes, Tuesday is there.
23rd, 29th, 28th, I have case in place. 29th, madam.
ঠিক-
Yes, sir. Yes, ma'am.
Also.
29th. PDP.
There.
29th. Monthly DDT.
Lordship, oblige, Lordship.
Order number 9.
We are ready for other side is. Yes, your lordship, but the other side. Okay. Shall I start, your lordship? It will take certain time because I have to go through the judgment, your lordship. So this is for the second time when they have been discharged. I am coming with the sequence, your lordship. The charge sheet is filed on 30th December 2008 under section 120B, read with 302 of the IPC against Ripan Bora, Kamal Nath and Pulin Fukan. Krishna Hazarika and Vishnu had died at the time of charge sheet, so their name is their case is abated. On 1st September, Additional Session Judge Kamrup Gauhati framed the charges against Ripan Bora, Kamal Nath and Pulin. This is the sequence of the case because this is for the second time when the CBI has come for the revision. On framing of the charges, your lordship, the two criminal revision has been filed by Pulin Bora and other accused, both disposed of on 11th June 2013, quashing the impugn order with a direction to re-examine the case with an open mind in the light of the legal point and issues raised by the accused, and to go through the charge sheet of CID and CBI cases. So since it was filed earlier in the local thana, thereafter it is transferred to CID, and then on the application filed by the brother of the deceased, by filing a WPC, this has been transferred to CBI, and the CBI has undertaken the investigation. So when the CBI has filed the charge sheet against Pulin Bora, Ripan Bora, Kamal Nath and Puneet Fukan, the charge were framed. They have come for revision, and at that point of time, it has been remanded again to the additional session judge, Kamrup at Gauhati, with the direction to re-examine the case with an open mind and in the light of the legal point and issue raised by the accused, and to go through the charge sheet of the CID and CBI. On 10th February, the Learned Trial Court discharged the respondent accused Ripan Bora and Pulin Fukan. And that is why this revision filed by the CBI, Your Lordship. So I have to go through this judgment, which is a self-explanatory, and it has been given in detail, Your Lordship. It is at page number 24, Your Lordship. By this order, I propose to answer the issue as to whether there are material on record to frame the charges against accused Ripan Bora and Pulin Fukan. In short, the relevant facts of the case are as follows. On the night of 27/9/2000, Daniel Topno, a popular Tea tribe leader of the Sonitpur district, was murdered on the road of some unknown person while he was riding on the bicycle. Regarding the said incident, on the basis of the FIR filed by the date of incident itself, by one Sri Manik Dhara, Gohapur PS, number dated so and so, was registered. Initially, the case was investigated by Assam Police, but later on, investigation of the case was handed over to the CID. Assam. Subsequently, the CID submitted a charge sheet in respect of the said case in the court of SDGM Biswanath Charali against two persons, namely Narayan Gaur, Umakanta Mizar, alias Kala Mizar. In the charge sheet, the second accused was shown as an absconder. While the case was being investigated by the CID, Santosh Topno, brother of the deceased, filed a WPC number 6198 of 2000 in the Gauhati High Court with a prayer to hand over the investigation of the case to CBI. The said petition was disposed of by the Honorable High Court on 17/5/2005, directing the CBI to investigate the case. Thereafter, the State of Assam filed a review petition number 82/2005 in the Honorable Gauhati High Court, praying for recalling the order of the CBI investigation on the plea that the CID has already completed the investigation and submitted a charge sheet against two persons on 30/10/2024. The said review petition was disposed of on 26/8/2005, and the Honorable High Court maintained its earlier order on the consideration that CBI had already started investigation of the case as per the order of the Honorable High Court. On the basis of the order of the Honorable High Court, the CBI registered the FIR number so and so, Kolkata, and after completion of the investigation, submitted a charge sheet against accused Ripan Bora, Kamal Nath, alias Ankur Nath, and Pulin Fukan. On the basis of the said charge sheet, by the order dated 1/9/12, the Additional Session Judge Kamrup Gauhati framed charges of murder with conspiracy against all three accused above named. It appears from the record that the said order of framing charges against them was subsequently challenged in the Honorable High Court by accused Ripan Bora, Pulin Fukan, by criminal petition number so and so. The said two petitions were disposed of by the Honorable Court by the order dated 11/6/13, by which the impugned order dated 1/9/12, framing various charges against the accused petitioner, was quashed, and the case was remanded to the trial court for fresh decision. The Honorable High Court was of the view that the learned Additional Session Judge Kamrup framed charges against the accused person solely on the basis of the charge sheet submitted by the CBI, without looking at the merit of the charge sheet that was earlier filed by the CID. In the opinion of the Honorable High Court, in view of the case of Vinay Tyagi versus Irshad Ali, alias Deepak, and others of 2013, it would be proper for the learned judge to go through both the charge sheet filed by CID and CBI and to compare the merit and demerits of the case before taking a decision regarding framing of charges. As the charges framed against the accused person was quashed and the case was remanded for fresh decision, the Honorable High Court also passed order for transfer of the instant case from the Court of Additional Session Judge Kamrup Gauhati to this court so that the case can be re-examined with an open mind. Subsequently, by an order dated 13/8/13, passed in the connection with criminal MC number so and so, the record of GR case number so and so pending in the court of SDGM Biswanath Charali was directed to be transmitted to this court for enabling to compare the charge sheet filed by CBI with the earlier charge sheet filed by the CID Assam. During the course of hearing in this court, accused Kamal Nath took the plea that he was a juvenile at the time of alleged incident. So for the first time he has taken this plea, Your Lordship, here. In the first, when the charge was framed, he has never taken this plea. For the first time, while it was remanded back, he has taken this plea. Kamal Nath took the plea that he was a juvenile at the time of the alleged incident. After going through the evidence of all the witnesses examined by the aforesaid accused petitioner in respect of this plea of juvenility, and also taking into consideration the report of the medical board constituted for determining the present age of the accused Kamal Nath, this court, by order dated 18/12/13, held that on the date of incident, that is on 27/9/2000, accused Kamal Nath was juvenile. Accordingly, he was directed to appear before the Juvenile Justice Board, and the board was directed to take up the follow-up action as per the law in respect of the said accused. I have heard the submission of the Learned Counsel of appearing for CBI and the accused Ripan Bora and Pulin Fukan. I have also perused the case diary and connected record in respect of the charge sheet filed earlier by CID, including the entire record and documents filed along with the charge sheet that has been filed by the CBI. The Learned Counsel appearing on behalf of the CBI has referred the following case. These are the list of the case laws, Your Lordship. Thereafter, I am coming to the page number 6, Your Lordship. The submission of the defense side is that the proper way to approach the case involving a confession of a co-accused is a first to marshal the evidence against the accused, excluding the confession altogether from the consideration, and see whether it is believed a conviction could safely be based on it. It is capable of belief independently of the confession, then it is not necessary to call the confession in aid. Cases may arise where the judge is not prepared to act on the other evidence as it is stand, even though it believed it would be sufficient to sustain a conviction. In such an event, the judge may call in the aid of confession and use it to lend assurance to the other evidence and thus fortify himself in believing what without the aid of the confession he would not be prepared to accept. According to their contention in this case in hand, apart from the confession of co-accused Kamal Nath, there is no other evidence connecting the other two accused, namely Ripan Bora and Pulin Fukan, with the charges leveled against them. The Learned Defense Counsel further urged that where the only defense before the court is a confession of the co-accused, it will have to be presumed that there is no legal evidence warranting the framing of charges. It may be taken a notice in the charge sheet filed by the CID out of two accused against whom charge sheet was submitted, namely Narayan Gaur and Umakanta Mizar, alias Kale Mizar. The relevant record of the court of SDGM Biswanath Charali reveals that due to death of accused Narayan Gaur, the case against him now stand abated. It also appears that the other accused, Umakanta Mizar, who was shown as an absconder in the charge sheet filed by the CID, is yet to be arrested and brought to trial. The charge sheet of the aforesaid case also divulges that Ripan Bora, who was arraigned as an accused during investigation of the case, was however not sent up for trial. As per the version of the charge sheet filed by the CBI, deceased Daniel Topno was a crucial factor in the assembly election from Gauhati constituency. According to them, investigation has revealed that the late Daniel Topno was a popular social figure in the tea garden belt due to his various social work, including establishment, running a middle education school, which Uttar Chatram ME school. He was a headmaster of the school right from the time of its establishment He had also unsuccessfully contested the assembly election in 1991 and 96 as independent candidate and also as a Congress Tiwari candidate. He was in a position to secure a large number of votes from the tea garden worker. He was preparing himself to contest the assembly election in the year 2001, in which ultimately Sri Ripan Bora from Congress party was elected. According to CBI version, investigation has also brought out that Daniel Topno had become a crucial factor in the assembly election from Gopur constituency, as even from the previous election result. Daniel Topno secured 7,658 votes in 1991 assembly election and 10,661 vote in 1996 assembly election from Gopur constituency. In 1996 election, Ganesh Kutum AGP secured 33,664 votes as against 31,131 votes secured by Ripan Bora Congress. It is therefore clear that the Daniel Topno by securing of 10,661 votes had tilted the scale in favor of AGP candidate and had caused the defeat of Ripan Bora. Cornering the substantial number of votes in 1991-96 assembly election by Daniel Topno has thus tilted the scale in favor of the Congress or AGP. Therefore, the contesting of Daniel Topno in the assembly election that was to be held during 2001 would have been a decisive factor to decide its outcome. Before the assembly election of 2001, Daniel Topno was approached by Ripan Bora, Manikumar Subba and other to join the Congress party. However, prior to his death, Daniel Topno was in touch with the AGP but had not decided anything, whereas to join Congress or any other political party. After the death of Daniel Topno on the night of 27/9/2000, while the case was being investigated by CID, one local newspaper, I Saptaha, reportedly published a news report on 9/3/2006 about certain disclosure made by Kamal Nath about the Daniel Topno murder case and his involvement in the said case. Based on the information published in the newspaper, suspect Kamal Nath was accordingly contacted by the investigating officer on 28/6/2006 for the first time. Subsequently, 29/5/27, a statement of Kamal Nath was recorded under section 164 of the CRPC by Srimati M. Datta, Special Judicial Magistrate, Gauhati. In his aforesaid statement, accused Kamal Nath has disclosed that during the relevant time, he was engaged as a driver of Krishna Hazarika from the year 1999 to 2002. In the month of January 2000, Krishna Hazarika took him to Chilarai Hotel situated at Gauhati. In the said hotel, he, along with the Vishnu Saikia and Krishna Hazarika, went to the upstairs of the said hotel and he was introduced to Ripan Bora and Manikumar Subba by Krishna Hazarika. He was also reportedly informed that Ripan Bora would fight assembly election from Gopur constituency and Manikumar Subba would fight a MP election from Lakhimpur constituency. He was present when there was a discussion going on between the Krishna Hazarika and Manikumar Subba and Ripan Bora. During the conversation, Manikumar Subba offered rupees 10 lakhs, saying that Daniel Topno should be killed. Krishna Hazarika then told that the rupees 10 lakh would be a small amount, and then Ripan Bora said that if he wins the election, he would pay rupees 15 lakhs out of 15 lakhs, but if he loses the election, then he would pay only rupees 7 lakhs. Along with Manikumar Subba, one person in civil dress was present and he handed over a bag containing rupees 12 lakh to Krishna Hazarika. At that time, accused Pulin Fukan was also present at the place. Krishna Hazarika then handed over the bag to him and thereafter he, along with the Vishnu Saikia, came out of the hotel room. After some time, Krishna Hazarika also came out and handed over the rupees 2 lakhs to him in 2 bundles. He kept the money in VIP suitcase and put the said luggage in the back seat of the Tata Sumo vehicle. Thereafter, he, along with the Krishna and Vishnu, came to Eden Hotel where Vishnu handed him a bundle of rupees 2 lakhs with the instruction to donate the said money to some religious institution such as Kamakhya Mandir, Deosal Mandir and to some orphanage. The rest of the money was instructed to hand over to Srimati Pinky Hazarika, wife of Krishna Hazarika. During his stay in the said hotel for several months, Krishna Hazarika and Vishnu came there several times. After some months, One day, he, along with Vishnu Saikia and Krishna Hazarika, went to the Gauhapur in Tata Sumo vehicle and reached Gauhapur around 2 a.m. night. At that place, Krishna Hazarika showed them a residence of Ripan Bora, Pulin Fukan. They reportedly stayed for the night in the residence of Pulin Fukan. On the next day afternoon, he heard Pulin Fukan telling Krishna Hazarika to bring one or two siprang, digging implement made of iron, from the house of Narayan Gaur and to place this instrument at the place of murder. Vishnu Saikia disclosed that he would kill Daniel Topno around 4 p.m. on the day. Krishna Hazarika, Vishnu Saikia and Pulin Fukan reportedly went to Arunachal Pradesh border, leaving Kamal Nath in the residence of Pulin Fukan. During the night, they returned back and instructed Kamal Nath to sit in the driver's seat. Pulin Fukan reportedly brought one siprang-like instrument and one kukri from his residence and boarded the vehicle. During the time when he was driving the vehicle, he heard some disagreement amongst Vishnu, Krishna and Puli regarding murder of Daniel Topno. All of them thereafter reportedly came to the house of Narayan Gaur, and from the residence of Narayan Gaur, Pulin Fukan reportedly brought one sandal, and thereafter all of them went near residence of Daniel Topno. Near the railway line, the vehicle was stopped and all of them got down from the vehicle. Kamal and Vishnu sat down on the railway line, and then they heard voice of Krishna Hazarika, an unknown person. Later on, he came to know that the voice of the unknown person was of Daniel Topno. Thereafter, he, along with the Vishnu, went near the place of occurrence. There he saw a Krishna Hazarika hitting Daniel Topno on his shoulder by means of belcha sovel. The blow was intended for the victim's head, but it hit him on his shoulder. Thereafter, Daniel Topno was chased down and was beaten by Krishna Hazarika. As a result, Daniel fell down on the ground. Krishna Hazarika carried one AK-47 weapon, but he did not use it. Krishna Hazarika then took out two kukri and gave several blows on the various part of the Daniel Topno. When the victim started raising hue and cry and the villager came running, they all moved away from the place. While Pulin Fukan ran away from the spot, Kamal Nath, Krishna Hazarika and Vishnu Saikia fled away from that place in the Tata Sumo vehicle, and during their return journey, the kukri used by Krishna Hazarika was thrown away by him in the river Brahmaputra. Thereafter, all of them returned to the Hotel Eden. In the said hotel, Krishna Hazarika offered him 80,000, which he refused to accept. The further version of the Kamal Nath is that while they were coming back from Gopur, Pulin Fukan confirmed the death of Daniel Topno to Krishna Hazarika over telephone. The CBI has contended that accused Kamal Nath was taken under the police custody to all the location mentioned in his statement and identify the relevant spot. In his statement recorded under section 164 CRPC, the accurately mentioned the wound inflicted on the deceased Daniel Topno, his description of the injury and the nature of the weapon used find corroboration in the postmortem report. His statement has further been corroborated by the recovery of the Hawaii sandal of Narayan Gaur from the place of occurrence. According to CBI, while the investigation was in progress, accused Ripan Bora tried to bribe rupees 10 lakhs to the previous investigating officer of the case, Sri A.B. Gupta, Deputy SP CBI, for cleaning his name from the instant case, and Ripan Bora was accordingly arrested and charge-sheeted. This attempt to bribe the investigating officer by Ripan Bora, according to CBI, is one of the incriminating circumstances to indicate that Ripan Bora was involved in the killing of Daniel Topno. The further contention of the CBI is that the investigation conducted by them has thus disclosed the accused Ripan Bora, Kamal Nath and Pulin Fukan, Krishna Hazarika and Vishnu Saikia entered into criminal conspiracy to murder the Daniel Topno as he was planning to contest assembly election against Ripan Bora, and if that would have happened, Ripan Bora's prospect to win the election would have been diminished. According to CBI, therefore, Ripan Bora hired a Krishna Hazarika, Vishnu Saikia to execute his plan to eliminate Daniel Topno, and accordingly, on 27/9/2000, Krishna Hazarika, Vishnu Saikia, Pulin Fukan, and Kamal Nath killed Daniel Topno. Accused Ripan Bora, Kamal Nath, Pulin Fukan, Krishna Hazarika, and Vishnu Saikia thus committed the offence punishable under section 120B IPC, read with section 302 of IPC. Accused Kamal Nath, Pulin Fukan, Krishna Hazarika, and Vishnu Saikia also committed a substantive offence punishable under section 302 of IPC. According to the charge sheet filed by the CBI, the allegation against Manikumar Subba as narrated in the confessional statement of Kamal Nath could not be substantiated and therefore he was not sent for trial. Now let me scrutinize the material on the record to find out whether there are any ingredient for framing of the charges against the accused Ripan Bora and Pulin Fukan. It is well settled at the stage of framing charges. The court is not expected to go deep into the probative value of the material on record. If on the basis of the material on record, the court could come to the conclusion that the accused could have committed the offence, the court is obliged to frame the charges and proceed to the trial. There is a case of Omar Abdul and Sakur so and so. If on the basis of the material on record, a court could come to the conclusion that the commission of the offence is a probable consequence, a case for framing of charge exists. To put it differently, if the court were to think that the accused might have committed the offence, it can frame the charge. Though for conviction, the conclusion is required to be that the accused has committed the offence. It is apparent that at the stage of framing of charges, probative value of the material on record cannot be gone into. The material brought on record by prosecution has to be accepted as a true at that stage. Framing of charges is an exercise of the jurisdiction by the trial court in exercise of section 228 of the code unless the accused is discharged under section 227 of the code. Under both these provisions, the court is required to consider the record of the case and documents submitted therewith, and after hearing the parties may either discharge the accused or where it appears to the court and it is opinion there is ground for presuming that the accused has committed an offence, it shall frame the charge. Once the fact and ingredient of the section exists, then the court would be right to presuming that there is a ground to proceed against the accused and frame the charge accordingly. This presumption is not a presumption of law as such. The satisfaction of the court in relation to the existence of constituent of an offence and the fact leading to the offence is a sine qua non for exercise of such jurisdiction. It may even be a weaker than the prima facie case. There is a fine distinction between the language of section 227 and 228 of the code. Section 227 is an expression of definite opinion and judgment of the court, while section 228 is a tentative. Thus, to say that at the stage of framing of charge, the court should form an opinion that the accused is certainly guilty of the committing an offence is an approach which is impossible in terms of section 228 of the code. At the initial stage of framing of charges, the court is concerned not with the proof but with the strong suspicion that the accused has committed an offence, which if put to a trial could prove him guilty. All that court has to see is that the material on record and the fact would become compatible with the innocence of the accused or not. The final test of guilt is not to be applied at that stage. Reading the two provisions of section 227 and 228 together in juxtaposition as they have got to be, it would be clear that at the beginning and the initial stage of the trial, the truth, veracity and effect of the evidence which the prosecutor proposes to adduce are not to be meticulously judged, nor is any weight to attach to the probable defense of the accused. It is not obligatory for the judge at the stage of the trial to consider in any detail and weigh in a sensitive balance whether the facts, if proved, would be incompatible with the innocence of the accused or not. The standard of test and judgment which is to be finally applied before recording a finding regarding the guilt of or otherwise of the accused is not exactly to be applied at the stage of deciding the matter under section 227 or section 228 of the code. At that stage, the court is not to see whether there is a sufficient ground for conviction of the accused or whether the trial is sure to end in the conviction. A strong suspicion against the accused, if the matter remains in the region of the suspicion, cannot take the place of proof of his guilt at the conclusion of the trial. But at the initial stage, if there is a strong suspicion which leads the court to think that there is a ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. The presumption of the guilt of the accused, which is to be drawn at the initial stage, is not in the sense of law governing the trial of criminal case in France, where the accused is presumed to be guilty unless the contrary is proved. But it is only for the purpose of deciding a prima facie whether the court should proceed with the trial or not. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if it is fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. If the scale of the pan as to the guilt or innocence of the accused are something like a even at the conclusion of the trial, then on the theory of benefit of doubt, the case is to be end in his acquittal. But if on the other hand, it is so at the initial stage of making an order under section 227 or section 228, then in such situation, ordinarily and generally, the order which will have to be made will be one under section 228 and not under section 227. The contention of the CBI that the accused Ripan Bora was arrested and charge-sheeted when he tried to bribe the former investigating officer of the case to clear his name from the instant case cannot be taken into consideration to be an incriminating material against accused Ripan Bora because of the simple fact that the said charge sheet and the proceeding emanating therefrom has already been quashed by the Honorable Supreme Court by order dated 7/12/11 passed in connection with W criminal number so and so. The next argument of the CBI is that the poll analysis of the assembly election of the Gopur constituency for the year 1991 and 96, which make it known that votes polled by the denial topno was determining factor, also cannot be said to be a correct hypothesis. To take an example, in 1991 election, Ganesh Kutum, who fought as an independent candidate, was actually a rebel candidate of Assam Gana Parishad party. The official AGP candidate Moti Bora and rebel AGP candidate Ganesh Kutum together secured around 16,665 votes, and the Congress candidate Koseswar Burwa, who won the election, secured 16,891 votes. In the said election, Ripan Bora did not contest. The Daniel Topno, who fought the election as an independent candidate, got 7,658 votes. It is thus clear that the Congress candidate could win because of the division of the votes between the defeated candidate and especially for the fact that the AGP failed to put up a combined fight. The contention of the CBI that the poll analysis of the 1996 Assembly election of Gopur constituency also support their contention that the deceased Daniel Topno, who secured 10,661 votes, tilted the scale in favor of the AGP candidate Ganesh Kutum, who secured 33,664 votes as against 31,131 votes secured by Congress candidate Ripan Bora, appears to be not a clear and specific projection because in the year 1996, Koseswar Burwa of the Congress party fought as an independent candidate and secured around 4,660 votes. Because of this split of vote between official Congress candidate Ripan Bora and the rebel Congress candidate Koseswar Burwa, AGP candidate Ganesh Kutum won the election. Thus, if the Daniel Topno is termed as a crucial factor for the defeat of the Ripan Bora in 1996 Assembly election of Gopur constituency, the same logic can be also said to be a pertinent for the rebel Congress candidate Koseswar Burwa, who secured around 4,660 votes, because the difference of the vote of the winning candidate Ganesh Kutum and the votes secured by the defeated Congress candidate Ripan Bora in the 1996 Assembly election of the Gopur constituency was only 2,533 votes. In view of the scrutiny depicted above, the submission of the CBI that the probable contest of the deceased Daniel Topno in the Assembly election of 2021 would have been decisive factor to decide its outcome, because by securing substantial number of votes in 1991 and 1996 Assembly election pertaining to Gopur constituency by deceased Daniel Topno tilted the scale in favor of the Congress for AGP candidate cannot be said to be a rational conclusion. Looking from another angle, the said conclusion also cannot be accepted because of the fact that even if the Daniel Topno is eliminated from the contest, there is no guarantee that all the votes likely to be polled in favor of the Daniel Topno would come to the fold of the accused Ripan Bora. The poll analysis projected by CBI is also simply a presumptive deduction. The supposition that the particular candidate will win the future election if the particular candidate does not contest the said election is nothing but a prediction based on the surmises and conjectures. The poll analysis of 1991 and 1996 result of the assembly election that has been taken into consideration by CBI, as I pointed out in the foregoing paragraph, is also appears to be not a correct proposition if one takes into the consideration that not only there were some rebel candidate in the fray, but a number of other candidates also participated in the said election, resulting division of the votes, and the votes secured by those candidates, if taken into consideration, will show that the number of votes polled in favor of the Daniel Topno in the said two election cannot be strictly said to be a decisive factor which tilted the scale in favor of the winning candidate. Thereafter, this citation has been given. The Honorable Supreme Court has observed that the presumption can be drawn only from facts and not from the other presumption by a process of probable and logical reasoning. Now, at page number 18, in view of the above discussion, I am of the opinion that the presumption relied by the CBI, taking into consideration the poll result of 1991 and 1996 poll result, to derive the point that the contest of the deceased Daniel Topno would have been a decisive factor in the election 2001 is nothing but a presumption drawn from the other presumption, lacking any probable and logical reasoning, and therefore this contention cannot be taken into consideration as an incriminating material against accused Ripan Bora that he had a reason to eliminate Daniel Topno to secure his winning in the assembly election of 2021. Another contention of the CBI is that prior to the assembly election of 2001, Daniel Topno was approached by the Ripan Bora, Manikumar Subba and other to join the Congress party, but the deceased, who was in touch with the AGP, did not take any decision whether to join the Congress party or any other party. This contention, even if is accepted to be correct, in my considered opinion, cannot be regarded as an incriminating material to lay the blame on accused Ripan Bora. Simply making a request to formidable T tribe leader of the locality to join the Congress party by Ripan Bora, who belonged to a Congress party, cannot be said to be an uncalled for request. In this respect, this is also to be kept in mind that there is nothing on record to suggest that Ripan Bora applied any pressure tactics or threatened Daniel Topno that if he failed to accede to their request to join the Congress party, he would face a dire consequences. In the instant case, it is an admitted fact that none has witnessed the murder of the deceased Daniel Topno. On perusal of the narration of the charge sheet filed by the CBI, it appears that the charge sheeted accused person had been sought to be prosecuted primarily on the basis of the exculpatory confessional statement of the co-accused Kamal Nath. It may be mentioned herein that the said statement of the co-accused Kamal Nath, recorded by judicial magistrate, has subsequently been retracted by the accused above named. It is also to be noted, it is also to be taken note that it has now been held that on the date of the alleged incident, Kamal Nath was juvenile. It is found from the record that out of the person named by Kamal Nath, Manikumar Subba was not sent up for trial, since according to by CBI, the allegation against him, as mentioned in the statement of the accused Kamal Nath, could not be substantiated. It is also revealed to notice that the other two accused persons, Krishna Hazarika and Vishnu Sekia, are now dead. It is settled principle of law that Section 30 of the Indian Evidence Act permits only a limited use of the confession as against the co-accused to whom a major role is ascribed by the confessor. It is well settled that the confession made by one accused can be used against the co-accused even when the other conditions under Section 30 are satisfied only for the purpose of corroboration of other evidence. In the case of so-and-so, the apex court, on the question as to how far and in what way the confession of the accused person can be used against the co-accused, has observed that it is not a evidence in the ordinary sense of the term, and it does not indeed come within the definition of evidence contained in Section 3 of the Evidence Act, because it is not required to be given on oath. nor in the presence of the accused, and it cannot be tested by cross-examination. Obviously, such evidence is evidence of the very weak type, and that it is much weaker type of evidence than the evidence of an approver, which is not subject to any of those infirmities. Such a confession cannot be made the foundation of the conviction and can only be used in support of the other evidence. Thereafter, case of so-and-so of the Gauhati High Court has held that in dealing with the case against the accused person, the court cannot start with the confession of the co-accused person. It must begin with other evidence adduced by the prosecution, and after it has formed its opinion with regard to the quality and effect of the said evidence, then it is permissible to run to the confession in order to receive the assurance to the conclusion of the guilt which the judicial mind is about to reach on the said other evidence. In that case, the Honorable Gauhati High Court has also relied upon the judgment of Haricharan and so and so. As a result of the provision contained in Section 30 of the Evidence Act, the confession of a co-accused has to be regarded as amounting to evidence in a general way, because whatever is considered by court is evidence. Circumstances which are considered by the court as well as probabilities do amount to evidence in that generic sense. Thus, through confession may be regarded as a evidence in that generic sense because of the provision of Section 30. The fact remains that it is not a evidence as defined by Section 3 of the Act. The result, therefore, is that in dealing with the case against the accused person, the court cannot start with the confession of a co-accused person. It must begin with other evidence adduced by the prosecution, and after it has formed its opinion with regard to the quality and effect of the said evidence, then it is permissible to turn to the confession in order to receive a assurance to the conclusion of guilt which the judicial mind is about to reach on the said other evidence. Thereafter, the Suresh Chandra versus so-and-so. The law is therefore quite settled that although the confession of co-accused can be taken into consideration and can be regarded as a evidence, it cannot be treated as a substantive evidence. It can only be looked into so as to throw light to give assurance to other substantive and independent evidence. In other words, there must be a substantive and independent evidence connecting. Yes, Your Lordship. It is at page from 23, Your Lordship. Now let us consider what the other material are apart from the confessional statement of the accused Kamal Nath that have been unearthed by the CID and CBI to indicate the complicity of the accused Ripan Bora, Pulin Fukan in respect of the murder of Daniel Topno. In the case diary of the Gohpur police station investigated by CID, none of the witness has said anything against the accused Pulin Fukan. In his statement before the police, witness Bakul Tamuli had stated that on being instructed by the Ripan Bora, he met Daniel Topno and requested him to join the Congress party. The statement of the said witness revealed that later on Daniel Topno came close to Assam Gana Parishad, but when he was asked to whether he had joined AGP, Daniel answered in negative. Likewise, Narayan Gaur, since deceased, who was charge sheeted by CID, disclosed in his statement recorded by police that Daniel Topno revealed before him that on the instruction of the Ripan Bora, he had been approached by Bokul Tamuli and Buddheswar Das with the proposal to join the Congress party. The other mention about Ripan Bora is found in the statement of Amarendra Kalita. According to his rendition before police, one day while he was sitting in the residence of Ripan Bora, he heard Bokul Tamuli and Ripan Bora engaged in a conversation regarding the appeal made to the Daniel Topno to join the Congress party. He could learn from the said discussion that as directed by the Ripan Bora, Bokul Tamuli and Buddheswar Das met Daniel Topno and requested him to join Congress party, but he was found to be not so enthusiastic about the said proposal. The further version of the Amarendra Kalita is that the Ripan Bora then reportedly told Bokul Tamuli to make a further effort to bring Daniel Topno to Congress fold, as this would be quite a crucial factor for his Ripan Bora win in the Gohpur constituency. The above statement obviously cannot be regarded as an incriminating material to lay the culpability of an accused Ripan Bora, because making a mere request to be a formidable T tribe leader of the locality to join his Congress party cannot be said to be a request to be looked with jaundiced eye. Going through the statement of the witness examined by CBI, it is found that none has said anything against the accused Ripan Bora or Pulin Fukan to indicate that they were involved in the conspiracy and murder of the Daniel Topno. Only police officer Mr. N. Singh has stated before the investigating officer that the accused Kale Mizar was picked up by him during the investigation of the case relating to the murder of the Daniel Topno, and during his interrogation, Kale Mizar reportedly stated before Mr. Singh that Ripan Bora had instructed him to eliminate Daniel Topno since he did not accept the proposal to join Congress or to refrain to contest assembly election. The further version of this police officer is that under political pressure, the statement of Kale Mizar was not recorded and he was allowed to abscond. The above statement of the police officer cannot be accepted to be a strong material against the accused Ripan Bora, mainly for the two reasons. The prime being that the confessional statement made before the police officer is inadmissible. Secondly, it appears from the record that during the relevant time, the said police officer was posted as a sub-divisional police officer of Biswanath Charali, and he was supervising the investigation of the case regarding the murder of Daniel Topno. From the record of the case diary of the said case, Gopur PS number so and so, it appears that nowhere in the case diary or his inspection note it has been mentioned by the said supervising police officer about this purported disclosure made by the accused Kale Mizar. Rather, if the said statement is believed, it lends credence to the charge sheet filed by the CID against the accused Narayan Gaur and Kale Mizar. It is also revealed that during the investigation of the case by Assam Police, the statement of Kale Mizar was recorded, but in his said statement, he has not mentioned anything that he was instructed by accused Ripan Bora to eliminate Daniel Topno. It may be mentioned here that the Kale Mizar, who was charge sheeted by a CID, was not examined as a witness by CBI. The CBI has mentioned in their charge sheet that the allegation made against the Narayan Gaur and Kale Mizar in the charge sheet filed by CID could not be substantiated by the investigation of CBI. It is well settled principle of law that at the stage of framing of charges, if there is no evidence except the confession of co-accused, a charge cannot be framed on the mere probability of the prosecution that at some future date, prosecution might produce future evidence supplementing its case. Trial cannot be allowed to proceed on contingent, hypothetical, and anticipatory evidence. Thereafter, these are the evidence. Then I am coming to page number 26 under section 30 of the Evidence Act. A confession of the accused is relevant and admissible against the co-accused if both are jointly facing a trial for the same offense. In the instant case, it is to be kept in mind that accused Kamal Nath, being now declared as a juvenile, he is not tried jointly with accused Ripan Bora and Pulin Fukan, and therefore his confessional statement cannot obviously be used under section 30 of the Evidence Act against the other two co-accused above named. As a result, if the statement of the Kamal Nath is excluded, then there are absolutely no material on record to set up the accusation against the accused Ripan Bora and Pulin Fukan. The said confessional statement accused Kamal Nath therefore cannot be called in aid to frame the charges against the accused Ripan Bora and Pulin Fukan in absence of any other evidence to do so. Thereafter, it is the paragraph from the judgment it has come. And lastly, I am coming to the page number 27. In view of the above discussion, it is held that there is no sufficient ground for proceeding against the Ripan Bora and Pulin Fukan, and accordingly, both of them are discharged as per provision of section 227 of the Code of Criminal Procedure, and the record of the GR case number so and so pertaining to so and so Biswanath Charali may be returned to the said court. Now here, the legal point is that, Your Lordship, when for the first time he has raised with regard to the issue of juvenility, he has been sent to the juvenile board. However, yes, Your Lord, my concern is that at least some report may be called for, because under section 94 of the Juvenile Child Protection Act in the 94, it has been given that it has to be verified whether he is a juvenile from either from the birth certificate, and if it is, but that report has not called for by the trial court below. And moreover, in his 164 statement, Your Lordship, he has given his age as a 28 years. I am coming to his 164 statement.
That report was called for by the child, not correct, man.
So, because it is not,
While he is called juvenile is claimed by the trial court, the report was called for and his ossification test was done. Then after this, he was declared juvenile. It's not correct proposed.
maybe I am subject to correction, your lordship.
That's
It is not
fine.
with me because I was not there in the, so I be subject to correction, your lordship. Now his, but in the, his 164 statement at page number 54, and his age was shown as a 28 years and he was the driver at that point of time. He has confessed that he was a driver from 1991 to 1999 to 2000. So,
Why the current trial court has not taken into account his statement in paragraph number.
yes, in the last paragraph, your lordship.
Not jointly, not right, jointly with report for and for that therefore is the document. And not obviously you addressing it's other co-accused.
Other two co-accused.
While arriving at such a finding, trial court relies upon the decision of. Sorry, it is a Bombay High Court.
It is a Bombay. But obviously, if he is a juvenile, then he cannot be tried jointly. So in that point of view, when other evidences are there, the circumstantial evidences are revealing that there is a conspiracy to kill him, Daniel Topno. Other circumstantial evidence coming from the record, because certain recoveries are there, and whatever the statement given by the Kamal Nath, which is recorded, maybe he is a juvenile, it has a relevance with the post-mortem report with regard to the owns and recovery. It has a relevance with the post-mortem report. It's matching with the post-mortem report, your lordship. So other circumstances is clearly reveal that there is a conspiracy in between them to eliminate the Daniel Topno. Looking to the other documents. So at this stage, at the stage of framing of the charges, only the prima facie case has to be taken into account, your lordship. Because at the stage of appreciation of the evidence can. Yes, your lordship, looking to the.
Elaborately discuss the provision of the provisional law system and also the rights of the case. And also discuss with every.
So these are required to be discussed. These are required to be discussed only at the stage of trial, your lordship, and while framing the charges. Beg your. Looking to the circumstances prevailing at that point of time, your lordship. Other circumstances revealing from the evidences recorded by the CBI personnels and their witnesses, because there are as many as 18 witnesses are examined during the course of investigation. There is no eyewitness.
Basically of the present complicity of the respondent getting with the offense list. So your case is based on circumstances.
Yes, circumstantial evidences are there, and look.
One thing. You declared a list of circumstances which the CBI has relied upon. Yeah. and also find out how the trial court has dealt with the same and what wrong with the finding of the trial court. We keep the matter as part of the.
As your lordship pleases.
Here to lead to that each. And one problem for the response. So, the last week of May.
Let me see, Aji, the first week of May time. Aji, এটা মেথ ফিক্স হয়েছে না মেথ নয় 6 মেথ হয়েছে 8 মেথ হয়েছে not possible on first week. It may be second week of May. 13 or 14. 13 or 14. Huh? এখানে 13 and 14 করি আছে to Hokkaido is in there. That reflected.
Well,
13 or 14th of May, as per the convenient of other side also is.
We have no idea.
No, first week. No, first week, some other cases are already fixed, prefixed. So. Then maybe on 6 or 7.
7th May.
7th May.
First.
Much
I'm
of-
appearing for the informant. Mine, informant. Yeah, respondent number 3.
Respondent number 3.
Obvious.
Much obvious.
Item number 11.
Mr. Lordship, kindly the matters is possible for the day. I have taken consent from the S folio. S for. 4 weeks. After 4 weeks. Okay.
Items 12 and 13.
Mr. Ahar Dubey appearing in this case, my lord. He is outside the court. I will call, my lord.
Item 14.
My senior is coming.
My lord, two cases are tagged together, that is RSA number 90 and 91. The first one is, my lord, RSA number 91. My lord, before I should take your lordship to the factual matrix of the case, as well as I would like to take your lordship to the page number 8 to 13, my lord, which is the judgment in title appeal number 2/2014.
RSA number 91 of 2017.
90, yes, my lord, 91, RSA 91, 2017. My lord, the two substantial question of law was framed by Honorable Justice. Yes. My lord, the first substantial question of law is, my lord, for that the substantial question of law is whether the first appellate court, being the last court of fact and law, was right in deciding the appeal without discussing the evidence on record as required under section 96 of the CPC 1908. My lord, this is required to be modulated. This is required to be modulated because 96 itself deals with the appeal against the supplemental proceeding. So this is required to be modulated, my lord, by your lordship. Second substantial question of law is that the substantial question of law is that whether the courts below were right in dismissing the suit of the appellant plaintiff by applying the doctrine of lis pendens, when admittedly the sale deed standing in the name of the appellant plaintiff vendor, namely Srimati Runuma Kalita, was executed by Nurul Islam Barbhuya, defendant of TS number 350 of League 1995, much prior to the filing of title suit number 350 of League 1995, and neither the said Srimati Runuma Kalita nor the appellant was made party to TS number 350 of League 1995 in order to show whether there was any lis pendens or not. And thereafter, my lord, any other substantial question of law that may be formulated at the time of hearing. So just to apprise your lordship whether there is need to any formation of any substantial question of law as stipulated herein, my lord, I would just request the honorable court to peruse Annexure A, page number 8, my lord, which is the judgment of the title appeal, number 2, my lord. My lord, this judgment was pronounced on 8/8/2016 by the Additional District Judge, FTC number 3, and page number 9, no doubt, my lord, contains the issues, but with the same submission before your lordship, though your lordship has well dealt in a recent case about the formation of Order 41, Rule 31 or not, that I will come to. My lord, kindly, at a glance, peruse this. No issues are either mentioned, no substantial question of law is framed. From page number 9, yes, issue-wise, yes. Points for determination is not there. Issues are no doubt reproduced from from the case record as well as from the judgment. But if I can take your lordship to page number 9 onward, at the last, the issues are there, all 6 or 7 number of issues. Thereafter, kindly peruse, my lord, page number 10, 11, 12. So this judgment is neither discussed issue-wise, nor any points for determination is framed. Whether issue-wise deliberation is also not there. Issue-wise, my lord. Yeah, issue-wise deliberation is not there. And the issues are also not discussed properly. I will take your lordship to the judgment to justify my contentions. So, my lord, let us go to this judgment itself first. Thereafter, I will come to the substantial question of law. May I read, my lord, the judgment?
A substantial question of law has to be made on this point.
A substantial question of law has to be framed, my lord, on Order 41, Rule 31. By your lordship, through the pen of your lordship. Though I have gone through the very recent judgment of your lordship, which was Pinaki Sharma, which was a good way.
My submission for your lordship's consideration would be, my lord, there is no substantial question of law arises in this. My lord, if your lordship would kindly see the prayer made in the suit. The title suit, my lord, there is a prayer is that the judgment and decree passed earlier, my lord, is liable to, my lord.
31, my lord.
But my submission would be, my lord, it has been complied with. Reason being, my lord, the appellate court need not, my lord, go in detail. My lord, if there are reasons in support of that judgment, my lord, that would suffice. My lord, I'll show from the judgment, my lord, that the court has dealt with the issue. It's not that the issues has not been dealt with. Yes, yes, my lord, I'll respond.
If you will appreciate them. My lord, first of all, I would like to take your lordship to the judgment of the first appellate court. This appeal filed under section 90, under section 96 read with order 41 CPC by the appellant against ten, my lord. So paragraph number 5, my lord. Yes. At the end, learned trial court, on conclusion of evidence of the parties, proceeded to hear the arguments before passing the judgment dated 25/11/2013, dismissing title suit number 27104 of the appellant primarily on the ground that the sale deeds of the appellant as well as her vendor were hid by the doctrine of lis pendens as contained under section 52 of the Transfer of Property Act. So this is one very important point which I would like to. नहीं है क्या?
10, na?
नहीं, page number 10, para 5. My lord, just a second. Yeah. 91.
First appellate judgment.
RSA 91.
Judgment of the.
First appellate court. My lord, again I am reading, my lord, that paragraph. At the end, learned trial court, on conclusion of evidence of the parties, proceeded to hear the arguments before passing the judgment dated 25/11/2013, dismissing title suit number 271/04 of the appellant primarily on the ground that the sale deeds of the appellant as well as her vendor were hid by the doctrine of lis pendens as contained under section 5 of the Transfer of Property Act. The suit filed by her husband was also dismissed on the same ground by a separate judgment delivered on the same day, for which separate appeal is being preferred. Being highly aggrieved and dissatisfied with the judgment and decree dated 25/11/13, passed by the learned trial court in TS number 271/04, the appellant preferred this appeal, challenging the said judgment and decree dated 25/11/2013 on the following amongst other grounds as stated in the memo of appeal. I have heard learned counsel for the appellant as well as the respondents and gone through the record with impugned judgment and decree. The main point for bone of contention between the parties to this appeal that the suit filed by the appellant being a declaratory suit simpliciter with the relief of recovery of possession and not for partition, and as such the suit ought not to be dismissed on the ground of non-joinder of pro forma defendants against whom the suit is said to have been dismissed for want of steps. Further, it is stated that learned trial court has misread the facts and evidence on record, and thereby came to erroneous conclusion that the sale deed of the appellant plaintiff and her vendor were hid by doctrine of lis pendens as provided under section 52 of the Transfer of Property Act. Whether the vendor of the appellant, namely Mrs. Runuma Kolita, purchased the land in question from one Noor Islam Borbhuya on 7/2/95, and the suit bearing title suit number 350/95 was filed by the present respondent only on 3/11/1995. So, my lord, in order to appreciate what is lis pendens, these two things are very important, my lord. The date 30/11/1995, when the title suit was filed, title suit number 350/95 was filed. And my lord, the date on which my vendor had purchased the property, Runuma Kolta, 7/2/1995. 7/2/1995. I will make my submission. First, I am reading, my lord, this judgment. Thus, taken into consideration the main point in this appeal, for determination, let me go through the pleadings and contentions of the parties. The appellants filed the title suit number 271/04 for declaration of a right, title, and interest over the shoot land and recovery of possession with permanent injunction. Further declaration that the decree in title suit number 350/95 was obtained by playing fraud upon the court, and as such, same is not binding upon the appellant and her husband. My lord, one thing I would like to mention here, that this title suit number 271 was given the number 271 only in the year 2007. Earlier it was, my lord, old TS 272/04. Thus, taken into consideration the main point in this appeal for determination, let me go through the pleadings of the contentions of the parties. The appellant filed the title suit 271/04 for declaration of her right, title, and interest over the shoot land and recovery of possession with permanent injunction, and further declaration that the decree in title suit number 350/95 was obtained by playing fraud upon the court. As such, the same is not binding upon the appellant and her husband. The respondents registered the suit of the appellant by filing written statement containing inter alia that the appellant and her husband never came to possession of the shoot land. In fact, the respondent number 2 and 3 purchased an area of 1 bighah of land, and the respondent number 1 and her husband purchased 2 bighah land by registered sale deeds from Maulvi Mehruddin in the year 1978. And since the day of purchase, they have been purchasing the entire 3 bighah of the land, including the shoot land, by mutating their names in the land records and by paying land revenue to the authority. As the vendor of the appellant, namely Nur Islam Barbhuya and one Jalil Ali Laskar, Abdul Jalil Laskar and Sajid Ali, dispurchased them from the area of 1 bighah of land, 1 bighah of their purchased land. They were compelled to file title suit number 390/95 and title appeal number 35/99, which being decreed in their favor. The title appeal number 1 title execution number 1/2032 was filed for execution of the decree. Thus, they were handed over possession of land by lawful order of the court. The respondent stated that they also in the meantime sold out 2 kattha 10 lecha of land out of 3 bighah by registered sale deeds to one Jayanta Talukdar and Hiren Chandra Kalita already. It is settled law that when the party pleaded existence of a fact to obtain a decree, must lead evidence to prove the fact in order to get favorable decision of a court. Therefore, the appellant was duty bound to tender evidence in the above aspect in order to get the decree of declaration that the decree in title suit number 350/95 is illegal, void, and not binding upon her as prayed for. On perusal of the record, it appears that the vendor Nur Islam Barbhuya executed the sale deed on 7/2/95 in favor of Srimati Runuma Kalita, who was the vendor of the appellant, whereas title suit number 350/95 was filed on 30/11/95 by the respondents. Thus, this means that TS number 350/95 was filed after execution of the sale deed by Nur Islam Barbhuya. Hence, the provisions under section 52 of Transfer of Property Act does not hit to the case of the vendor of the appellant. However, the sale deeds of the appellant was executed during pendency of title suit number 350/95, and as such, the principle of lis pendens attracts to the case of the appellant. Therefore, the appellant cannot acquire right, title, and interest over the shoot land on the strength of sale deeds. Learned trial court, as such, rightly came to conclusion that the case of the appellant is hit by lis pendens, and as such, there is no right, title, and interest of the appellant over the shoot land. Hence, I affirm the decision made in issue number 4 by the learned trial court. As far as the evidence of the appellant is concerned, it appears from the record that the appellant stated in her evidence that she was shocked and surprised to note that her vendor since 7/2/95 was in possession of 1 bighah of land since 7/9/99 and 10/9/99 respectively. She along with her husband came into possession of the said 1 bighah of land, yet neither her vendor nor her husband or herself was made party or informed about any suit and proceeding pending in the court over the said land. which was in occupation of her, and she was illegally evicted from her purchased land without notice of any kind. Apparently, the land was purchased by the appellant in 1999, whereas the title suit number 350/95 was filed much earlier than her purchase of land, and as such, it is correct to say that the appellant cannot be made party in the suit. Therefore, on the basis of such evidence of the appellant, it cannot be held that there was any scope for making the appellant a party in title suit number 350/95. However, it appears that the vendor of the appellant, Mrs. Runma Kulta, was made party in the above suit, but she did not contest the suit. Perhaps the vendor of the appellant, knowing of the above filing of the suit, hurriedly sold the land to the appellant. It appears that learned trial court held in issue number 1 that the suit is bad for non-joinder of necessary party. It appears that actually the appellant arrayed all the sharers and her vendor a party in her suit, but due to lack of steps on the part of the appellant, the suit was dismissed against them. However, it goes not to say that the appellant did not seek any relief from those parties against whom the suit was dismissed for want of steps. Therefore, these parties are not necessary or essential party to the said suit of the appellant. Hence, I do not subscribe to the view made in issue number 1 by the learned trial court. Since the appellant did not acquire her right, title, and interest over the land due to bar under Section 52 of the Transfer of Property Act, on the strength of a lawful decree, the respondents initiated the execution of the decree, and she was lawfully evicted from thereof by way of process of law. It cannot be viewed that the appellant was illegally dispossessed from the suit land. Apparently, the decree passed in title suit number 350 is binding upon the appellant, as she did not have any right, title, and interest over the suit land. As says, the appellant is not entitled to get a decree. Hence, the view of the learned trial court does not suffer from any illegality on the related issue. In the light of the above finding, I find that there is no infirmity or illegality committed by learned trial court while dismissing the suit of the appellant plaintiff. The impugned judgment and decree is hereby affirmed and upheld. Thus, I am of the view that the appeal has no merit, and accordingly it is dismissed. Prepare a decree, no order as to cost, send back the record, giving under the hand and seal of this court on the 8th day of August. So and so. This is the judgment, my lord. Now, what are the issues, my lord? The issues are reflected at page number 9. Issue number 4 and issue number 1. Yes, my lord. Issue number 1 is whether the suit is bad for non-joiner of necessary parties, and whether 4 is whether the plaintiff has right, title, and interest over the suit land. That's what my submission is before your lordship. Though my lord has already dealt in detail, my lord, in this Pinaki Prasad Vishwas case, I have brought that judgment, my lord, of your lordship, though it is there. But your lordship has also come to the finding that if any matter is decided issue-wise, then there is no question of framing any, the substantial question of law to the tune of Order 41, Rule 31. So, my lord, if that question is framed, I would like to satisfy your lordship whether my suit falls within the provisions of this Section 52 of the TP Act, whether I am bound by that decree which was passed in title suit number 350/95. And that too, as per the own submission and record which they have submitted before the learned trial court, that in one side of their boundary, my name is shown. My name is shown. I will start from Mehruddin, then Sayyid Ali, my lord, then Nur Islam, then my lord, Runuma Kalita, and then they are purchaser, my lord. Yes, my lord.
But in fact, the lordship would see the judgment of the trial court. Your lordship also has to see the prayer that has been made. My lord, if your lordship come to the title suit. The issues are not page 9.
My lord, it appears 6 issues, my lord.
Lord, I would submit, Lord, these are consequences of the issues that has been decided. My lord. The requirement of order 41. So 31 has been complied with. Look, the trial court in general also have discussed all the issues. I'm not on the legal proposition of that. But whether that would be applicable in this case, not is an issue for you. Because what the trial court has given a finding, based on that, not the appellate court has decided. Irrespective of other issues decided or not, this will clear the issues. Yes. Secondly, it has also directed that we discuss on issue wise. But two of the main issues. Yes. But in fact, there is no finding on. But in fact, therefore, there is a requirement of that your lordship can frame, whether it's tenable or not, that will your lordship would decide. Yes.
Yes. My lord, my lord.
Yes.
Yes, my lord.
First of all, issue to as a blanket issue. That's not accommodated at the so, directed that we discuss on all the issues. And it has only discussed like number 4, next number 1. There is finding that's like other. That's the requirement of order 21. And that's such a self-post or
for determination. So, I discuss this all this. As a by order for favor. Part, some items. For order getting one question.
My lord, any date after 22nd of May, my lord.
After 22nd,
Hi.
26th May.
Right. मैंने अभी है
Item 14,
May please your lordship. Lordship, petitioner is aggrieved by the judgment and order dated 30/4/2015, passed by the learned Additional District Judge 1 Kamrup, Gauhati, entitled Appeal number 13/2012, allowing the appeal by declaring the suit of the plaintiff by the reversing the judgment and decree dated 27/9/2012, passed by the learned Civil Judge number 3, Kamrup at Gauhati, in title suit number 186/1996. Lordship, before I'm taking the substantial question of the law, Lordship, I'm just taking the plans of the plaintiff, Lordship. Page number 6 onwards, Lordship. And it is starting from the page number 7, Lordship. I'm reading the page number 7, Lordship. Number 1, that your humble plaintiff is a resident of the so-and-so, 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 and is forced to got himself a degree of contract of business, not only to engage so-and-so, so-and-so. And number 2, that during the year 1994, the defendant number 2 entered into a contract agreement bearing number so-and-so, dated 21/1994, with the pro forma found defendant number 4, Lordship, for the performance of the work of the clearance of damage and garbage from the goods shed line at NGC, BG and NG goods, and dumping the same by the truck loaded at the rate specified in the schedule, the agreement, Lordship. Be it mentioned herein that the rate specified in the said contract agreement for per truck loaded of the sale 4.8 meter long and 2 meters broad and 1.4 high, both is figure and marks was fixed at the rate of rupees 995 only. That in pursuance of the above said contract agreement, the pro forma defendant number 4 reportedly started work of the clearing the damage and garbage, but the said work could not be carried out for a much longer period by pro forma defendant number 4, and as a result of which a series of the derailments
derailment of loaded and empty wagons took place. The pro forma defendant the pro forma defendant practically left the job in the undone condition, Lordship, and this created a diptic situation, and the railways were in desperate need to make same alternative arrangements. The urgently and nature of work required immediate action, immediate action, and this left the DRM Lamding defendant number 2 with no action and other alternative than to restore to other means and measures to remove the damage and garbage in order to avoid derailments of wagons, and such as defendant number 2 call plaintiff required from him as to whether he was in a position to carry out the work, and on getting the answer in the affirmative, he gave verbal instruction. And engaged him. This is a very important part, Lordship. He means DRM, defendant, gave a verbal instruction, Lordship, engaged him to clear the garbage and damage from the track of MG and BG goods shed, with the assurance that the written works order shall be issued, with the assurance, Lordship, in due courses of time. But the most unfortunate part is that till date, no formal work order has been issued, though in the records of the railway administration, the quantity of the work carried out by the plaintiff is duly noted and recorded. It would not be out of the place to mention here that the plaintiff, as on after receiving the verbal assurance and on realizing the emergent and serious nature of the work, started the work of the clearing the garbage and damage on and from 6/3/1994 on the existing rate quoted white contract agreement number GMG so and so dated 21/1994. Lordship, here actually this date which is mentioned is not with the plaintiff. This is with the pro forma defendant, Lordship. That for the purpose of executing the work, the then DCN Sri A.K. Burman on 4/3/1994 took to the plaintiff to New Gauhati BG shed in order to show the site of the work and also to get the plaintiff introduced with other staff of the said BG shed, so that they may allow the plaintiff to carry out the work, and accordingly the plaintiff was allowed to take his laborers and trucks, etc., up to the site within the yard where entry is prohibited and regularized, and the plaintiff and his staff did not face any difficulties on this account. That thereafter the plaintiff started the work into removing the garbage and damage on and from 6/3/1994 and submitted the first bill on 23/3/1994 for 50 numbers of trucks in total, and even till then the written work order was not issued to the plaintiff. However, the plaintiff was again asked to go ahead with the work and was assured that not only formal work order would be issued to him, but also his payment will be cleared, and accordingly the plaintiff cleared out the work and submitted the bills from time to time and received the assurance of the DRM and DGM, but the pending bills will be cleared. That the plaintiff, on assurance of the defendant, number 3, carry out the work to the utmost satisfaction of the defendants and accordingly submitted the bills from time to time, and altogether he submitted 3 bills, that is on 23/3/1994, 19/4/1994 and 28/5/1994 for total sum of rupees 1,49,250, the details of which are as herein under. And next paragraph, it is so and so. Amount is so and so, Lordship. That details the bill date-wise. He submitted. That out of the above referred bills, not even a single paisa was paid to the plaintiff in spite of his repeated demand. Then the plaintiff on 18/9/95 even sent one letter narrating the entire facts and thereby claiming on amount of rupees 1,49,250 for the works done in furtherance of the verbal instructions of the defendants, but to his utter dismay, no response was paid to his letter dated 18/9/1995. It may be added here that the work carried out by the plaintiff was a commercial transaction and he was legitimately entitled to receive payment of his dues within 30 days of submission of his bill. But the same was not done and the plaintiff was unjustly deprived of users of his own money, for which the plaintiff is also entitled to claim interest. That thereafter the plaintiff on various occasions approached Lordship. Should, yes, Lordship. Appellate court, first appellate court. That is page number 25 onward, Lordship. May I read it, Lordship? This is an appeal under section 96, read with order 41, rule 1 and 2 of the Code of Civil Procedure 1908, read with section 151 of the CPC, preferred against the judgment and order dated 27/9/2012, passed by the learned civil judge, senior division number 3, Kamrup at Gauhati, title suit number 186, 1996, for setting aside the impugned judgment and decree. The case of the plaintiff appeal in brief is that the appellant filed on title suit number so and so in the court in the Learned Civil Judge, Senior Division 3, Kamrup M, Gauhati, where it was tried and finally adjudicated by the judgment dated 21/6/2007. The appellant being aggrieved by the said judgment preferred an appeal before this court, and the same was registered as title appeal number 10/2007. The said title appeal was transferred to the Court of Learned Additional District Judge FT1 Kamrup Gauhati, and who by his judgment dated 18/4/2011 was pleased to remand the suit by setting aside the trial court's judgment dated 21/6/2007 with a direction to call for Railway Administration file number TFC Commercial Branch pertaining to clearance of garbage and damage and relating to the contract of the Kumel Khan for the work from the respondents of the defendants, and to give opportunity to hearing after receipt of the said file to both sides and to decide the suit afresh. The file relating to the Kumel Khan's work was not called for, and the judgment was pronounced on 27/9/2012, which the appellant considered to be perceived bad, and hence the appellant is preferring this appeal based on facts and circumstances which are as under. The appellant, after his retirement from the defense service in the Indian Air Force, got himself engaged in petty contracts to earn his livelihood during the course of such engagement. The appellant approached the divisional railway manager, NF Railway Lamding, that is respondent number 3, seeking such contract, and coincidentally, the DRM was then in a serious emergency, as there was a leftover part of work done through a contract entered into the pro forma defense respondent number 5, who in fact failed the contract halfway for inexplicable reasons. The appellant plaintiff states that he was offered the contract orally by respondent number 3. This is the very important line, Lordship. Who issued to issue the formal order on regularization of the procedural formalities involved. The terms as ensured in the original contract and the same rate of rupees 995 per truck load, capacity of 4.5 meters long, 2 meters breadth and 1.5 meters height, as given in the schedule of the contract number CM/Danes/Garbage/SCL/93/14 dated 21/90/94. Lordship, this agreement was done with the pro forma defendant, not with this plaintiff, Lordship. Pertaining to the work of clearance of damage and garbage from the goods shed line at NGC, BG and MG goods, and dumping the same by truck load would apply, and the appellant readily undertook to execute the said leftover part of the contract. The appellant plaintiff mobilized his sources and engaged laborers, tools and vehicles for execution of the said contract, and with effect from 6/3/1994, the work was started, and the first engaged bill for 50 trucks loaded was submitted on 23/3/1994, followed by submission of subsequent bills 19/4/94 and 26/5/94 respectively, amounting rupees 1,49,250 only in all payment. However, as no payment was either found forthcoming or released despite Lordship. Yes. Lordship. Lordship. Lordship.
The issues have not been discussed. It is not a case for the Mr.
Yes, madam. Yes, madam. To formulate the point for determination, because that, yes, yes, madam. Very true.
Lordship, that is true. Lordship, we will find the everything, the judgment dated, title suit number 186 of 1996. It is clearly stated everything and all issues was discussed issue-wise, Lordship. By the court. That is trial court, judges, civil court judge number 3 Kamrup. No, it is against the appeal filed by the plaintiff or against the 3 bills pending. 3 bills pending they have filed. Impugn is this one, Lordship, which is still impugn judgment is this one. Impugn judgment is, Lordship, title 13/2012. Second appeal. Lordship.
Which judgment we have challenged? Impugning.
Impugn this one. Yes. Appellate court. Not, it is not, Lordship. Not there.
I also know this has nothing to do with
It is not, the issue has not been discussed. That is true, Lordship. My question, my substantial question is, Lordship, number 2, very important, page number 5. Whether the learned lower appellate court erred in law in decreeing the suit of plaintiff while plaintiff has failed to prove any agreement, either in oral or written, between the plaintiff and defendant. They have failed to prove that the agreement was made with the plaintiff and the authority. No agreement. Verbally, they have stated. They could not prove. But it is wrongly discussed, Lordship. It is discussed, but it is taken the wrong intention. Whether, number 3, my lord, whether the learned lower appellate court erred in not complying the provision order 41, rule 31 of the CPC in passing the impugn judgment and decree 34/2015 passed by the learned additional district judge 1 Kamrup. Appeal number so and so. What are these? The points for determination, the decision thereon, the reason for the decision. The reason for the decision. Reason is not properly given, Lordship, because our.
That's why.
Yes.
Therefore, the honorable court.
Lordship. Okay, Lordship. Yes.
I agree, my lord.
Yes.
While disputing of the statute, the learned person to the court has the figure formulated and harmful reduction thought. The timeline is recorded. Person of directed by personal sometimes. Who's the affected a lot of value. Taking back. Taking back. Also, in case that I order taken the while I think about there is something in the wisdom of law that there is something in law as the third substance involved rather than the first like a lawyer like part of the and when there's a I think hard learning from other parties and also going for the improved classroom. They feel fast by the learner, fast to be hard. It appears that the learner possibly has better formulated than one or directed discussion. Aspect of the 6 issues, especially the learning that it cannot be said that the learning plan for person transport has complied with the requirement of order 41 service. Accordingly, this 4 days of the new diagnosis is a big test. So it is like the judgment that order passed by the certain degree passed by the learned particular court and to revamp the method the learned particular court to pen all for different sheet and there to discuss the same like to record the finding of the recording to the accused judge and executive of the methods that the after the part the direct here goes the party judgments as to finding out the point for the this is the record of the part and the parties are directed to regulate for the on any business.
No, my lord, because it is department, so it will go here and there. After 6 May, June, make it June lordship at least.
First appellate court, my lord, will be additional session judge, district judge number 1.
Yes,
Yes. Here itself.
it is Gauhati.
Parties are directed to appear before the learned first appellate court and in the court of learned.
Additional district judge number 1.
Number
1.
number 1 on
Any day.
Oh, yes.
Oblige.
Oblige lordship.
yes.